Wait, this is a lordship, my lord.
Morning.
Item number 3, my lord.
Yes, Mr.
In the
Dekka.
IA, we have filed an objection, my lord, that may kindly be called for. And if it is not inconvenient, my lord, can it be taken up at 2 o'clock, my lord? Obliged.
You want to go and have your Vishwakumar lunch?
No, my lord. Mr. M.K. Chaudhary.
All right. I'm only on the lighter note, Mr. Dekka. Yes.
Thank you, Lordship. Lordship, Victim item number 34, Lordship.
Item number?
34.
Matter may be adjourned for the rest. Matter may be come after vacation, Lordship.
34.
34, Lordship.
Itu mark koi loise na duta boldat mark. 34 you want what?
Adjournment, Lordship.
You are for the
Petitioner, Lordship.
Hmm?
Petitioner.
as prayed for by Mr.
H. Islam.
H. Islam, learned counsel appearing for the writ petitioner, relist after 2 weeks on a date to be fixed by the registry. Yes, next.
Okay.
Item 12, Lordship. Lordship, in this matter, we were supposed to file our affidavit, Lordship. So kindly grant some time to file our affidavit, Lordship.
Have you taken consent from the other
Yes,
side?
yes, I am the other side. I've already given the copy, my lordship, earlier.
Item 12.
Item 12.
Item
12, Lordship.
Sorry?
Item 12.
Lordship.
As prayed for by MS
P. Rabha.
P.
Rabha.
Rabha, learned counsel appearing on behalf of Mrs. Agan.
Lordship.
Learned CGC, relist after 2 weeks to enable the respondent to file affidavit in opposition in the matter.
I'm for the petitioner, Lordship.
Next.
Please, the Lordship. Lordship, with the consent of the other side, I'd like to mention item number 16 to 26, your Lordship. So
Yes.
maybe granted some time to file our affidavit, your Lordship.
Lordship,
As prayed for, any objection?
no objection, Lordship. There are similar matters, 9 other similar matters, Lordship.
As prayed for, relist, as prayed for by MS,
H. Terangpi, your
H.
Lordship.
Terangpi, learned counsel, standing counsel,
Yes, sir.
learned standing counsel, SEC education, secondary education, relist after 2 weeks to enable the department file return in the matters. List along with, give that list,
9 matters, Lordship.
DD.
Lordship, interim is there.
Interim, if any, shall continue to the next date of listing.
Obliged.
2 weeks on a date.
Obliged, Lordship.
May I please, the Lordship?
List of the nidlo hoy along with counsel kare lagai dibo apra in one paragraph. Yes.
Item number 30, Lordship. We have filed our affidavit in reply, Lordship. Kindly, the record may be called for.
All right.
Obliged. May it pleases your Lordship. Lordship, I'd like to mention item number 62 of the supplementary list.
Yes. What do you want in 62?
We're supposed to file an affidavit in opposition. We will need 2 weeks' time.
Have you informed the other side?
Yes, Lordship.
Who's there for the petitioner? Anyway, you've informed.
Yes.
As prayed for by MS,
L. Izu.
so and so learned counsel appearing for respondent
2 and 5.
2 and 5, relist after 2 weeks to enable the said respondent file return in the matter with consent logging. Yes.
Very pleased, your Lordship. My Lord, item number 4, I have the instruction to do the same from my petitioner.
Item 4, MSS Bora, heard MSS Bora, learned counsel appearing for the petitioner. Also heard Mr.
No, Lordship, I'm not.
I inform SS Roy, CGC.
Anyone from CGC is here? Yes. MS B Devi, na? B Sharma, sorry. MS B Sharma, learned CGC. Yeah? MS S Bora, learned counsel for the petitioner, submits that she has received instructions from the petitioner not to press the instant writ petition and accordingly makes a prayer for withdrawal of the same. In view of the aforesaid endorsement, the writ petition stands dismissed on being withdrawn.
Obliged.
May it please your Lordship. Lordship, I beg to mention, with the consent of the other side, I beg to mention item number 9 of today's daily list.
Yes.
Lordship, the main arguing counsel in this particular case, Lordship, is having some personal difficulties, and we would like to seek an adjournment on that ground.
Lordship, kindly fixed on 22.
22 Parliament Lawrence dialogue as prayed for by Mr.
A. Bora's name is
Mr. A. Bora, learned counsel appearing for the petitioner. A. Borwa.
A. Bora. Lordship,
Bora.
I'm from the respondent side.
You are from the respondent side. And who's making the prayer?
I make the prayer, Lordship.
For the respondent.
For the respondent.
Mr. A. Bora, learned counsel appearing for the respondent.
NHN.
NHM. Huh? relist on such and such date.
Much obliged, Lordship.
Yes, call the list.
It is for withdrawal item number 16.
May I please your lordship? The petitioner got the relief lordship, so now he wants to withdraw.
Heard MSP
P. Haklari.
Kaklari,
Yes.
learned counsel appearing for the petitioner, also heard Mr. K. Bhuya, na? Learned counsel appearing for respondent number 10. 10. Anyone else? KC
Actually, I am for elementary education.
and MS so-and-so learned counsel appearing for the elementary education. Stop. None appears for the KAC on call. MS so-and-so learned counsel for the petitioner submits that she has, that since the petitioner has received the relief sought for in the instant writ proceeding, she has been instructed not to press the instant writ petition. In view of the aforesaid endorsement, the writ petition is then dismissed on being withdrawn. Infractious, on being infractious. KSC, give her name. Terangpina?
Yes. Sir.
For motion item number 1.
Family pension and pensionary benefits?
Yes.
Yes. Ms. Sharma, why it has not been given?
Lordship, yes, Lordship, that it's regarding section 106 of Evidence Act, Lordship. He went missing on 99. So now a report was submitted by the officer in charge of Maibong Police Station on 11/2/2025. I have to
think-
obtain instruction.
But then there's a rule 143 capital A, I think, for missing person.
But I have to, Lordship.
Where's the report? Where's the report?
Lordship, kindly peruse annexure to page 17.
Kali 143 capital A. Yes, which page?
Page 17.
Page 17.
Yes.
Yes.
Sorry, page 12.
What is 17?
The certified copy of the police report. Which the petitioner procured.
This is given by the officer in charge. Yes. Page 17. And page 12 is?
Missing report.
This is. You are the wife.
Yes.
You're the wife. The petitioner is the wife.
Yes.
So petitioner, only one petitioner.
Yes, Lordship.
Missing from 28/7/1999.
Yes, Lordship.
And where is your FIR? Has you filed an FIR? No, GD entry. Huh?
Yes, Your Lordship.
No, because this 12 says extract copy of MBS PSGD. Okay. Okay. And what is your relief here?
Uh, uh, Directing the respondent number 2 to release the forthwith benefits, including salary, leave encashment, retirement,
Where is
gratuity,
that rule?
back wages and promotional benefits, and also release family pension.
1 second. No? Pension release? This is under the state,
No,
the central. So is there any similar rule in the central?
should be there.
It should be there. Ms. Sharma, because under the Assam Service Pension Rule, there is a specific rule, 143A, where a procedure for family pension in case of disappearance of government servant is given. Okay. Now that says the only condition is that, first of all, of course, the disappears is not known, and then there is a two condition. One is that a report has to, a complaint has to be lodged, information, and then a report from the concerned police station that the employee had not been traced after all efforts had been made. Now it appears that here these things are there. So you find out that I can have this matter fixed on Friday. There is no requirement for filing detailed affidavit. If a requirement like this exists, we can dispose of by saying that the representation of the petitioner can be disposed of in exercise of that power.
Lordship, not on Friday, Wednesday next, Lordship.
Why?
Uh,
You just have to do some homework.
no, that's true, but I have to apply
Okay.
it.
All right, but Ms. Sharma, that is what, because you see there's no point of keeping this matter pending. It's a very short issue involved. If there is because there is a report. Now, if there is a report and if a similar power exists, that should be done. Why to keep this matter pending? Okay. You also look, is there any provision in the FRSR? Anywhere? You don't know.
And
Heard MS?
L Thakur.
L. Thakur, Learned Counsel appearing for the petitioner, also heard Ms. B. Sharma, Learned Counsel appearing for the central government. For all respondents,
No, for the 7, he is appearing.
you are for 1 to
6.
1
I'm
to
1 to 5.
1 to 5. And Mr. D. Bora, Learned Counsel appearing, Learned Government Counsel for the respondent number 6. The issue involved in this writ petition is release of family pension and other benefits to the family members of the disappeared employee. Stop. Issue notice returnable on such and such date, next Wednesday to review. On such and such date, extra copies by the within the course of the day. In the course of the day, MS B. Sharma shall obtain specific instruction as whether there is any provision for and or mechanism in order to provide family pensions and other benefits to the family members of a disappeared employee under the central government. Correct? Released on such and such date.
Likewise.
For address
Obliged.
station address number.
Referral.
Referral.
Yes, petitioner. Plan appears for the petitioner on call. Are you agreeable?
Yes, Your Lordship.
However, MS H. Terangpi, Learned Counsel appearing for the state respondent submits that last time also you had submitted and there was no call. What is the issue? Should we dismiss it for default then?
Your salary, Your Lordship.
It appears that none appears for the petitioner on call. Heard MS H. Terangpi, Learned Counsel appearing for the state respondent who submits that the matter can be referred to the mediation. It appears that on the last two consecutive dates, on the last date, I-9/9/2025 as well, there was no representation on behalf of the petitioner. Relist Friday, date to on such and such date in the under the column for dismissal in the order. We'll see on that day.
Yes, sir.
Orders, there's anything item number three.
Under the referral column with the remark for dismissal.
For
Okay.
example, item number 5.
Item number?
Fine.
Yes.
Understood, accept.
And appears for the petitioner on call relist after 3 weeks on a date to be fixed by the registry. It will go after the puja.
Item 6.
Lordship, here we received.
Yes, Mr. Gogoi?
Yes, we received a signed copy. There was direction to file affidavit. We're filing it today. Anyways, in
So you're filing it today.
today, but there's a similar judgment, your lordship. Which
Mr.
will pass by your lordship.
So last time it was cited, I was disagreed. That is why.
This is
we are
relating
asked
to Jal Mitra, your lordship.
All right, you file.
Wait,
Oh,
wait.
this is that Jal Mitra.
Jal
case.
Mitra case.
by lordship. This is order.
These are not maintainable.
Yes.
This petition.
Yes.
sir.
Here the petitioners are working as?
Lordship, he was recommended by the
Working as what? What post?
Jal Mitra lordship. His
Jal Mitra is the organization. They are as pump
post name
operators.
is operator. Yes.
Operator,
Yes,
pump
yes,
operator.
sir. Lordship, he is recommended.
One second, I'll hear you.
Yes,
I'm,
exactly.
you just.
Okay, okay. I'm sorry.
If the court is putting a query, first address the query. Huh? Yes, what is your submission?
Yes, Lordship, kindly come to page 17, the impugn order where I have put to silence in this writ petition. This order was issued by the executive officer PAC, and the judgment which they are relied, the appointment were purely by the private body.
In
But-
your case, can we see first your appointment?
No, Lordship, in this case,
Huh?
my challenge is that.
You don't have an appointment
No,
order?
no,
So there is no appointment
No.
order. Is there a better copy of page 17?
in my affidavit, Lordship, page 36. Here challenge my appointment, Lordship. Page 36.
Page?
36, Lordship, in affidavit of the private respondent number 8, Lordship.
Who are you?
I am Lordship respondent number 8, Private Sakir Ali. He has challenged my appointment, Lordship. I am working as Jal Mitra, Lordship. And here,
Mr. Gogoi, in this case, you file your return. File it next week.
Next week,
Heard, Mr.
is it
So and so learned counsel for the petitioner also heard Mr. R. Gogoi, learned standing counsel PHE, and Mr.
S.U. Ahmed,
S.U. Ahmed, learned counsel appearing for
8, respondent.
respondent number 8. Mr. R. Gogoi, learned standing counsel PHE submits that the affidavit is ready and the same shall be filed within the course of the day. So I'll list it on Monday.
Monday.
Relist on Monday or Friday?
Wednesday.
Monday, man. Friday, I mean this Friday. Monday, released Monday, huh? Yes. As Datta, na? For PNR, as sending out to PNR.
Item number 7.
Mr. Gogo, you clarify his appointment.
Very well, Lord.
Yes, what is this? Yes.
The small matter, my lord,
Check
regarding
it.
this compassionate appointment, my lord. Here, lordship will find,
Who
The-
died? Who is the deceased?
the son, my lord,
Son.
son.
When?
The son is the petitioner, my lord,
No,
father
the
died.
deceased.
Yes,
Father died.
father.
When?
He was expired on 3/8/2015, lordship.
3/8/15.
Yes. And subsequently, my lord, on 18/8/2015, just after 15 days, the
Application.
petitioner got the motorcycle accident, my lord, and accordingly, he got the 50% disablement now.
When did he make the
An
application?
application was made on behalf of the this son. The mother made the application on 5/10/2015. 10/10/2015. That is within the time.
Yes, then?
Then, my lord, the case ultimately in 2019, lordship will find
DLC recommended or
DLC.
rejected?
No, DLC rejected wrongly. It was rejected.
DLC rejected.
DLC rejected on lordship will find
Then
this.
what happened after the DLC rejected? I'm just taking note of the first
Yes,
of
yes.
points. What happened after DLC rejection?
DLC rejected on the ground. The ground is very, very peculiar. Man. The lordship will find page 46. Bottom.
Yes.
Navajit Bhagavati, the applicant.
Yes.
In the remark, lordship will find the proposal in respect of Sri Navajit Bhagavati, son of late Mukut Chandra Bhagavati, is examined. The father of the applicant was died on 3/8/15, but the applicant applied for appointment on 6/6/19. That last application was submitted 6/6/19. That has been reflected. But the earlier application, which was filed earlier, 2015, that has not been reflected. And that is why, after almost 4 years, his proposal cannot be considered as per para 3 of the OM.
After this, what happened?
Then, my lord, I applied for this RTI, my lord, since I did not get these minutes regarding rejection, all these.
So when
Next.
did you apply? On 10/4/24.
10/4, this is reply.
10/4/24.
It is the reply on the basis of my RTI.
And your RTI is also received on 13/3/24.
Lordship,
And this DLC rejection is in 19.
19.
And you filed this case when?
In 2024,
24.
Lord.
After this receipt of
Af-
the.
RTI.
Okay. Anything more?
Then, lordship, this application, one after another, this application was submitted in earlier occasion.
That's all right.
Then office memorandum is there,
Which office paper?
1/6/2015.
Yes.
It is the clear, my lord, even the post clause 15, page 55.
Hmm.
Clause 15, lordship.
Page.
Page 55, 55.
Page 55. Yes.
Clause 15. Alert this regarding vacancies. Even if sufficient vacancies are not available in any other particular office to accommodate the persons in the waiting list for compulsory appointment, it is open to the administration department or office to take up the matter with other departments, offices of the government to provide at the early appointment on compulsory grounds to those in the waiting list. Even in the case of the petitioner, that the vacancy did not, they did not say anything, only my application was rejected as because they have stated that it was submitted after 4 years. There are vacancies, so many vacancies, my lord. And by virtue of this, their submission,
Yes, yes, you can carry on.
29/1/2025.
Hmm.
This honorable court recorded their statement, my lord. They have stated before this honorable court that the case of the petitioner has been considered 29 January 2025. The office, the court's order, honorable court's order. And subsequently, when the government was directed to get the instruction, then government has said no such DLC was DLC considered. This wrong submission was made at the time. My lord. Now my only prayer before this honorable court, let the DLC consider all this aspect, my lord.
Okay.
Lordships.
Yes, Mr. Gogoi.
Lordship, the rejection as stated page 46, the rejection, it says that a proposal in respect of Shri Navajit Bhagavati, son of the Mukut Chandra Bhagavati is examined. The father of the applicant was died on 13/8/2015.
Yes.
But the applicant applied for the appointment on 6/6/2009, that is after almost 4 years. The proposal cannot be considered as a para 3 of the OM dated.
All right.
Now, Your Lordship, the thing is the application has been made by the mother of the applicant. If I may take it, Lordship, page 44.
No, page 46, they're talking about the father of the applicant.
Yes,
So that is the son.
that is Navajit Bhagavati is the son.
Is the son. What
Page-
happened to the mother's application?
Mother did not, mother applied for the son.
Where is that?
At page 44, my kindly look, Your Lordship.
On behalf of the son.
Yes.
In my repetition 27.
All right, all right.
Page 44, Your Lordship.
Yes.
Candidate name? Shri Navajit Bhagavati. Applicant?
Srimati Minu Bhagavat.
Yes. Date of death? 3/8/2015. Date of application? 2019.
Okay. Yes, now what is your defense?
Thing is that since there is no vacancy and as per this OMF clause 15, which says the, may I read
What
out?
about the delay?
Yes, Your Lordship.
What about the delay?
Delay is there.
Then why are you not focusing on the main point? What about Devabrata Tiwari?
No, that
But they have to apply within 1 year. They applied beyond 1 year.
Where is that 1 year?
At Lordship, at the OM, Your Lordship.
Where?
Page 51.
Page 51.3, Your Lordship. Every eligible dependent seeking
1 second. 51.
51 of the writ petition.
Yes.
Every eligible dependent seeking appointment under this OM shall make an application for appointment compulsory ground in the prescribed form with all the enclosure within 1 year from the date of the death.
Here, of course, 1 year, perhaps the son had some, he met with an accident and something had happened.
Yeah.
But suppose even if we keep all these things aside, the fact remain is that the father of the petitioner, the husband of the petitioner had expired on 3/8/2015. The DLC's rejection came sometime in 2019.
19.
The writ petition is filed sometime in 2004. correct?
24.
In fact, the RTI application was also made in 24.
Yes.
Now, this all shows lapses of several years since the death of the petitioner's husband. And what is sought is compassionate appointment,
Yes.
which is not a source of recruitment.
Yes.
Correct?
True.
The object of compassionate appointment is to give immediate
Immediate
relief.
assistance.
Now, here the sense of immediacy has already been lost and diluted. And in this whole interim period, it appears that they have been able to survive.
Yes.
That's all.
That part already, we have the judgment, my lord, division bench judgment.
What does the division bench say? That Debabrata Tiwari will be overlooked by the High Court?
No.
No, if there is a judgment of the division bench saying
Regarding
that
Debabrata,
Debabrata Tiwari cannot be looked into, please give it to me.
no,
Please enlighten the court.
yes.
Yes, please.
Lordship, kindly have a look this Abdul Qadir Bakshi case, the petition, my lord.
In Abdul
Sure.
Qadir Bakshi, I think that 18 memorandum was under challenge where
Yes.
there was a consensus.
Debabrata Tiwari on the basis of the.
Mr. Counsel, not on the basis of Debabrata Tiwari. In Abdul Qadir, Mr. Thor, Ms. Bhattacharya, this is that case, right? Where because there was a proposal given by the Advocate General and the parties there agreed, they said all these cases were that 18 the memorandum. What is that date? Correct. Wherever that memorandum is under challenge, they will all resubmit and the SLC will reconsider their case.
Exactly.
Also in terms of Debabrata.
Yes.
Give me that. Abdul. Oh, Mullah Nasir.
No, that part is already there. This honorable court has.
Mr.
already-
Chetri, this court knows. Yeah.
Yes,
Where is that? Give.
yes, I have.
Hey, Kalija Disla. Loya. Board kon loya.
Now, Lordship will find the relevant portion, my lord. Para 9,
All right. Noted.
para 9 and 10.
Noted.
Yes.
Yes. Anything more?
In this respect, my lord, para 10.
Yes. Read.
It is made clear that in view of the consent of the parties, this court has not gone into
In
the.
view of?
In view of, it is made clear that in view of the consent of the parties.
In view of the?
Consent of the parties.
Now read.
This court has not gone into the merits of any petitioner's cases that are being disposed of by way of this order, and as such, the applications for compensatory appointment should be disposed of by the concerned authorities on merit, as they deem fit and proper. The decisions to be taken by the concerned authorities should be based on the reasons, and the decision taken should be communicated to the petitioners thereafter. It is also directed that while deciding the applications for compassionate appointment, the respondents cannot take recourse to the impugned OM dated 18/9/2024. Though the judgment provided therein, that is the case of Debabrata Tiwari, can be considered applied by the concerned authorities. It is again made clear that this order cannot be.
Read it again, that line. Though the case of?
Though the judgment provided therein, that is the case of Debabrata Tiwari, Supra, can be considered applied by the concerned authorities, it is again made clear that the order cannot be used as a precedent for cases that are filed on 4/4/25.
That means after 3.
Thereafter.
After the date
Yes.
of the order.
Yes. And thereafter, it shall only apply to cases that are pending before this court as on.
Wherein? Complete.
Yes.
Wherein?
No.
It is there.
It shall only apply to cases
Yes.
that are pending before this court as on 3/4/25.
You missed out one paragraph.
Then
Paragraph 8.
yes,
Paragraph 8,
I'm
the
reading.
counsel for all the petitioners have submitted that they are agreeable to the proposal made by the learned AG, Assam, and as such do not wish to press their challenge to the impugned OM dated 18/9/2024.
In this
Now,
case-
para 9.
yes,
In view of the consent of the learned counsels for the parties, all the writ petitions that are pending as on today, I-3/4/2025, in the Guwahati High Court, which have put to challenge, the impugned OM dated 18/9/2024 are to be decided as
As
follows.
follows. Yes. Now, the one.
It's already, you've read it already.
No, this has not been read out.
Okay, read.
All the applications for compensation and
First
appointment.
and foremost, have you challenged this notification?
No, since
All right.
this OM this notification 18/9/2024. This has covered my case, my lord.
All right. Noted.
Para 20. All the applications for compensation and appointment submitted by the petitioner shall be considered and disposed of by the concerned DLC, SLC on merit by taking into consideration the various guidelines prior to 1/4/2017 laid down by the state government for compensation and appointment and the judgment of the Honorable Supreme Court and the High Court. Consequently, the rejection of all compensation and appointment by the DLC, SLC which have been put to challenge and are pending in the Guwahati High Court as on 3/4/25 are set aside. The entire process for considering the various applications for compensation and appointment and the decision to be taken in each case by the concerned authorities should be completed within a period of 6 months from the date of receipt of a certified copy of this order by the concerned district commissioner, who is also the chairman of the DLC, if the matter pertains to the DLC. In other cases, the Chief Secretary to the Government of Assam, who is the chairman of the SLC, if the matter pertains to SLC. Now, Lordship will kindly have a look regarding the delays. But if otherwise Lordship consider that delay, recently in one case, probably in 2025, after the Devadatta Tiwari, it has been said that the delay only may be factor, but only at the time of filing the application, that will be factor. But subsequently, as because he has come later, cannot be a
That
factor.
is after Debabrata Tiwari
After Devabrata.
and by Supreme Court.
Yes, 2025. I will place it
Give me.
today. I could not, my lord. I could
Then
not.
it's all right. I am not adjourning this matter. Anything more?
No, I will
Anything
place the
more?
matter. I will place the
The
matter.
matter is listed, Mr. Chetri. What are we doing for this long? After devoting so much, at 2 o'clock, you bring
Yes.
whatever decisions you want.
Yes.
No further time is going to
Yes,
be
yes.
given in this matter.
At 2, my lord. My lord, since on the same basis, my lord.
Very well. You can bring whatever decisions you want to rely and place it at 2 o'clock.
On the same issue, my lord, already we have argued the matter is under this for delivery of order, delivery of the.
Item 8.
Obliged, Lord.
What is this matter, Mr. Saikya?
My lord, in this case, the petitioners are not being paid the salaries,
Salaries.
my lord,
Since?
since 1996, my lord.
Why, Ms. Mushahari?
They were appointed against sanctioned vacant post. They were
Affidavits
working-
filed?
My lord,
Affidavits have been filed?
no, my lord.
Lordship, the last order, you said 23/5/2025, your lordship, there we had stated that a hearing was to be conducted on 4th of June 2025, your lordship. The hearing has been conducted. However, we do not have the updated instructions.
So you
your
get the up-to-date
Yes, your
instructions?
lordship.
Heard Mr. I.S. Saikya, learned counsel appearing for the petitioner. Also heard MS.D. Mushahari, learned standing counsel elementary. Secondary education. MS so-and-so submits that seeks a short accommodation to place up-to-date status as regards the
Yeah.
status of the
Yeah.
pending salaries due to the petitioners. Relist on such and such date. It was before vacation, did you? Before vacation.
My lord.
On 23rd.
Obliged, your
But Ms. Mushahari, please try and get the up-to-date status, huh?
lordship.
This 96 onwards, salary has not been given.
Okay.
That cannot go on like this.
Yes, sir.
Item 10.
Yes, Mr. Sharma,
Lordship, one IA has been filed for
Yeah.
impleadment
the IA is there.
for my learned friend.
You have filed the IA.
I'm for the petitioner.
No, who has filed the IA?
I'm fine.
For what?
For impleadment.
You want to be impleaded.
No,
Mr. Sharma, you're objecting.
No, no.
Then I'll allow it.
Yes,
More the merrier.
yes, no issue. Lordship, just fix the matter on 1510. One
Sir.
connected petition is also
Yeah.
there.
There is a connected petition.
Very well. Let me first
Yes.
allow the impleadment.
Yes.
You are who?
I have filed a impleadment petition as respondent number 4.
What is the I mean, in what capacity? Who are you? Because I need to put one line about your presence being required. That is why I'm asking. Who are you? Nivedita Kalita. Yes?
They have challenged a,
No, I
They-
have filed a writ petition for consideration of my promotion for the post of head assistant.
Hmm.
And my position is serial number 1 in the gradation list. My learned friend has filed an
Because the applicant is the senior, is claiming to be
claiming the
senior than you.
senior.
Okay, all right. Heard, Mr. N. Hawk,
my,
learned counsel appearing for the applicant. Stop. Also heard Mr. H. Sharma, learned counsel appearing for
Writ petition.
here you're responding.
Respond number 1.
One stroke writ petitioner. Anybody else?
Lordship, I'm appearing for
Mr.
health department.
Huh?
I'm appearing for health.
Sorry, I'm sorry, your name again?
M. Bhuya, Lordship.
M. Bhuya. M. Bhuya, learned counsel, standing counsel?
No, Lordship.
Learned counsel appearing for the health department. Stop. By way of this application, comma, the applicant is seeking impleadment as respondent number 4 in WPC 1350 of 2025. Stop. The reason in support of the impleadment prayer reads as under 2, 3, and 4. Reading of the aforementioned paragraph, it appears that since the applicant is the senior, is senior than the respondent number 1 stroke writ petitioner, the presence of the applicant appears to be necessary and essential for effective adjudication, necessary and proper for effective adjudication of the issue involved in the connected writ petition. That being so, the prayer for impleadment stands allowed. It is provided that the applicant shall, it is provided the applicant be added as respondent number 4 in WPC number 1350 of 2025. Then amended course title be submitted before the registry for doing the needful disposed of. In the main writ petition, you write, since you have appeared, so no notice is required. You file your return that in view of the order dated so and so allowing the impleadment, the new impleaded respondent number 4 is allowed to file return if so advised. List on?
On 15/10/2025.
It was already directed.
No, connected
okay.
writ petition.
List on such and such date along with
WPC number 5275/2025.
and number for Didiba.
Apply.
Mr. Sharma, please ask your junior to give that writ petition number so
Yes.
that there is no error.
Item 11.
Engage counsel seated as another box.
Sometime. Yes, Mr. Kashyap.
Lordship, they have not yet filed the reply.
Yes, may I please listen?
You'll file?
No.
You'll not file?
Just appeared filing the work also. 3 weeks time maybe granted.
Heard Mr. T. Kashyap, learned counsel for the petitioner. Also heard Mr.
He has it.
Huh?
He has
P.
it.
Hajorika, learned counsel appearing for
All the rest.
the respondents. In view of the appearance of so and so, the service in respect of all the respondents stands complete. Mr. So and so seeks 2 weeks, 3 weeks, 3 weeks time to file return in the matter. Prayer is allowed, relist after 3 weeks on a date to be fixed by the registry.
Also.
May it please your lordship.
Just 1 second. Yes,
May it please your lordship. The respondent authority are supposed to file affidavit.
Yes, my lord. I have received the paravis comment and I have made a communication for furnishing of the supporting document.
heard
That I
Mr.
need
P.
to look at.
Borderler, learned counsel appearing for the petitioner, also heard Mr.
Ji Jalan.
G. Jalan, learned counsel appearing for the respondent numbers 1 to 4. Mr. Jalan submits that he has received the instructions
Yes, ma'am.
and shall file the return within a short period of time. In view of the above, relist after 3 weeks
Yes.
on a date to be fixed by the registry.
Obviously.
Can that be fixed, lordship?
Hey, come, Mr. Counsel.
Oblige, your lordship.
You have any difficulty, please approach the bench.
Lordship. Item 15.
Lordship, can this matter be taken up immediately after vacation? Lordship, this matter is dealt by.
My lord, it
MS
is basically non-payment of salary, my lord.
Ah,
In
Mr.
the light of, my lord, the affidavit filed by the respondent number 2, my lord.
Why are you not giving salary?
My lord, I have,
You don't want the petitioner to enjoy the puja?
No.
Do you want this matter to go on?
Lordship, actually,
What are the reasons?
S. Sharma is handling this matter.
Who?
S. Sharma, Standing Council Health. If she is on leave, so immediately after vacation, otherwise.
Right, you are there.
Lordship,
You
I'm
find
there.
out
Yes, Lordship.
why the salary is not released.
my
So
lord,
far as Lordship, our affidavit says that he has joined in the Borpeta Medical College and since he has joined there, Lordship, so the GMCH has no role to pay the area salary claimed by the petitioner.
not I am claiming from GMC, my lord. Here is the case, my lord. I was transferred to the Fakhruddin Ali Ahmed as a registrar in Borpeta. While I was working there, then I have sent to,
GMCH,
no, my lord.
Borpeta.
No, my lord. Again, I have to send to Autonomous Council of another, my lord, Dimahasa Medical College. Since my salary has been withheld because of non-giving them by the GMC, my last pay certificate. That is the only case.
Then you, why are you not giving it? You release that whatever
Non-
certificate is
Yes, yes,
required.
Lordship, it says that he has not applied for the certificate. In
I have applied my.
Then I can dispose it off by saying that
My annexure is
that
there.
that
Yes.
you consider that application. Where is that application?
Application page 100, man.
Page 100.
100 and 100,
Mr.
203.
Upamanyu, right?
Yes, Lordship.
Mr. Upamanyu, what is the use of keeping these matters?
Yes, Lordship.
Page 100.
Lordship.
This is to the address to the commissioner.
Medical education.
So you want it to be addressed to a particular person.
Yes, yes.
He will
100
direct
also
it.
there.
He will submit it. There is no difficulty.
Yes, Lordship.
My lord.
If that is the issue, because he needs this certificate, you are not disputing all those positions. You look into it,
If necessary, I'll give fresh representation.
correct, and with all documents.
Yes,
Yes,
Lordship.
yes.
Lordship to respondent number.
Medical College Authority.
Non-receipt of release order and LPC from GMCH Guwahati, I have not been able to get payslip from the office of AG and get salary. And as such, I would like to request you to kindly take necessary step, the release order and
Last
this,
page.
you see this thing is already there, 13/5/2024.
Yes.
So we can dispose of by saying that to look into to consider this
Representation.
representation.
And
And
Lordship, in the meantime, petitioner may also file a representation to.
It is there
To
already.
the respondent number 5.
He shall submit the copy of the writ petition and along with any other documents if necessary.
To the
To hear
respondent.
the petitioner and
Yes.
pass it.
Yes, Lordship.
Yes. Heard Mr.
J.I. Barbia.
J.I. Barbhuya, learned counsel appearing for the petitioner. Also heard Mr.
The Upamanyu.
You, na?
D.
D, sorry. D. Upamanyu, learned standing counsel, Health Department, Assam. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking direction inter alia to the respondent authorities to forthwith release the last pay certificate as well as release order of the petitioner from Guwahati Medical College and Hospital, Guwahati, so as to enable the petitioner from getting the salary slip from the office of the Accountant General Assam, Bamuni Maidan, Guwahati, to get his area salaries with effect from 29/1/2024 to till the date of his resignation for the interest, full stop, resignation, full stop. Ero to me, Paba, paragraph, here it, page 27. The brief facts of the case is that the respondent authorities by order dated 18/1/2024 had revoked the suspension order of the petitioner and thereby transferred him and posted him as Registrar, Department of Pediatrics, Fakhruddin Ali Ahmed Medical College and Hospital, Borpeta, from Guwahati Medical College and Hospital, Guwahati, following which the petitioner had joined in the aforesaid place of posting on 29/1/2024, and since thereafter, the petitioner had rendered his service up to August 2024.
And in the meantime, I was
Thereafter, the petitioner was transferred by order dated 19/8/2024 and posted as Registrar, Department of Pediatrics, Difu Medical College and Hospital against the vacant post, releasing the post of against the vacant post. Stop. It is the specific case of the petitioner that though the respondent authority by way of order of revocation dated 18/1/2024 had transferred and posted the petitioner as Registrar, Department of Pediatrics, Fakhruddin Ali Ahmed Medical College and Hospital, Borpeta, however, the respondent's authority had neither issued release order of the petitioner from Guwahati Medical College and Hospital, nor issued the last pay certificate of the petitioner from Guwahati Medical College and Hospital, for which the petitioner, despite rendering his service at the Medical College and Hospital, had been depriving from getting his salary with effect from 29/1/2024. Stop. It is the it is the further case of the petitioner that despite several representations, no action has been taken by the respondents for issuing the last pay certificate as well as the release order thereof. A consequence of which the petitioner has not been paid his salary till date since the date of since he has joined at Fakhruddin, at the Fakhruddin so and so hospital, situated,
Till the date of this resignation.
not till date, Nokoba, has not been paid salary from the date of joining the said Fakhruddin so and so medical college at so and so till the date of his resignation. Situated thus the present writ petition. Mr. So and so, learned counsel for the petitioner, submits that despite the application filed by the petitioner, which is enclosed as annexure
23B ABC,
23 ABC, comma, to the commissioner and secretary to the respondent authorities, comma, the requisite release order and last pay certificate from GMCH Guwahati has not been issued by the respondents, failing which he has been deprived of his legitimate salaries. Stop. Mr. D. Upamanyu, Leonard so-and-so submits that the aforesaid application has not been,
He has not applied before the
he submit that the petitioner has not applied before the
Guwahati Medical College and Hospital Authority.
Guwahati Medical College
And
and Hospital.
Respondent number 5.
Respondent number 5, for which the prayer sought for by the petitioner in the instant writ petition has not been able to be for which the release order and the last pay certificate as sought for in this instant writ petition has not been issued till date to the petitioner. Stop. Having heard the learned counsels for the parties and having perused the averments made in support and the averments made in the and having perused the material available on record, I am of the it appears that the reason for not issuing the release order and the last pay certificate as sought for in the instant writ petition is due to the application having not been filed by the petitioner before the competent authority, i.e. respondent number 5. That being so, I am of the considered view that this writ petition can be disposed of in the interest of justice by directing the petitioner to file the representation stroke application afresh before the respondent number 5 with all the relevant documents, and as and when the respondent number 5 receives the same, and as and when the said application is made before the respondent number 5, the respondent number 5 shall, within a period of
10 days,
15 days,
Yes, sir.
15 days from the receipt of the such application, shall do the needful in accordance with law.
Where's my lord, I get my salary.
I said whatever is required will do. How can we give that direction?
Plus.
Disposed, ordered accordingly, disposed of.
Thank you, sir.
You give it before the puja.
27 to 29.
Yes.
Lordship, against the order of suspension, we have filed the first writ petition. And second, since they have not complied with the order, contempt application was filed. And third one is for non-supply of the copy of the inquiry report, third writ petition was filed. They have preferred one application for vacation of the interim order. Lordship, my urgency is that I'm retiring on 39, my lord. Intermatter can be taken off. I'm retiring on 39.
What is the issue in the original writ petition?
First, they have issued the order of suspension. It was interfered with by this honorable court. I was reinstated back into service. Then they have again issued another order of suspension, my lord.
Second suspension.
Yes, because their contention is that enquiry report, which was in my favor, they were not agreed upon it. But I was, Lordship, my case is that I have not been furnished with the order of report of enquiry, my lord. And second suspension, the same ground is not enabled in the eye of law.
You have filed how many writ petitions? Two writ petitions.
2027 is against the order of suspension.
The second suspension.
Yes.
2027 is the second suspension.
Yes.
Now, in that second suspension, there was an interim order.
Yes.
What is the interim order to the effect?
That it may be state. It is state.
The suspension.
Yes. They have
Now-
not complied.
Now they have come in an IA to
Yes.
for vacating
Yes.
that particular order.
Yes. In a subsequent repetition also. I
And
have
what is the status of the inquiry?
No, it was in my favor, they say.
But after that, there was a decision of re-inquiry.
Yes.
For
that's-
de novo.
They were not agreed with the report
Correct.
of the
Therefore,
inquiry.
disagreement.
Yes, disagreement.
And they
nothing
wanted
has been
to do a
submitted
fresh
now.
inquiry.
Yes. Now what they have done, they have annexed the order of enquiry, like report of enquiry with the IA, my lord. It is never been furnished to me. By way of the IA, along with the IA, they have annexed this one.
But Mr. Gogoi, before you take a decision of disagreement, is the petitioner not entitled for the inquiry report?
There are two issues, madam. first has no connection with the merit of this matter. First was only on the record principle that 90 days was referred to and review was not done. First it was closed. The other two before your lordship is, first is that we didn't furnish them copy. We didn't furnish them, and the learned single judge, my lord, while the honorable court, while dealing the matter, my lord, since we are not equipped with authority at the time with the any instructions, my lord, was pleased to have a view that we are at liberty to proceed, file an application for modification. Accordingly, we have filed this IA. Second petition before.
No, but whether inquiry was given, the report was given to them before you took the decision of disagreeing with the first inquiry report.
Prima facie, I shall be honest, my lord, prima facie.
It was not given.
It was not given.
Then,
my lord,
because this is all about fairness. You see, you may disagree. There is no difficulty for you to disagree. But when the first inquiry of this inquiry report, there could be something in their favor or whatever. So that normally before you take a call, whether you will agree, you disagree, because you see what is the genus of these things is the fairness,
right?
Correct? So before you take that decision, you have to give them a copy of the inquiry report so that they can, if suppose the inquiry report is against, or even if it is for, they can give you, if suppose you say that why should we not accept this, then they get an opportunity to give their explanation. Now, based on that, and reading with the inquiry, that is your prerogative.
Right.
You want to do a second inquiry, you want to do a third inquiry, you can go on doing it, but you have to do it in terms of the natural justice. You have to be fair. Fairness and transparency is all that is expected. Correct?
I'll beg to slide before my lord. The petitioner is on the impression that he has been acquitted of all the charges. Not like that, my lord.
That's because you have not given him
partially proved.
Inquiry report.
The entire edifice of this.
When the stay order is operating in my favor, they have issued another order dated 31/7/2025, whereby the order of suspension has been extended. Again, violation.
That is why I contempt.
Yes.
That is why I contempt.
No. Prior to that, we have.
What was the contempt for?
Contempt was for, because as of date, I have not been reinstated. For that, I have filed contempt application.
No, you are not reinstating also.
No, my lord, that is the.
Concession has.
Suppose there is an interim order to the effect that the second suspension is stayed. What is the consequence of that?
My lord,
what is
very order, my lord? That very order gives us liberty.
Huh?
That very order, my lord.
Where is that order?
That order is that page number 23 of the IA, my lord. The very order has given us the liberty to approach this court for modification of that order, my lord.
IA to joke. Yes. Page?
23, my lord.
Page?
It starts as page 21, concludes at page 23, the last paragraph.
Yes.
23 minutes. Accordingly, till the returnable date, the impugned order dated so and so shall remain suspended. However, the respondent authorities are at liberty to approach the court for modification of this order as the learned standing counsel expresses an inability to address the court on not being equipped with instruction from the department at this stage.
Where is that decision, Ms. Bhuyan, that the inquiry report has to be given to you before disagreement?
Oh, Lordship, ECR.
Please give me that. Because admittedly, that is the position.
Yes.
They are saying that they have not given.
9A also says so. Assam Service Discipline Appeal Rules.
Well, ECIL also has a test of prejudice. The
Yes,
person,
we will consider-
yes.
We will consider everything. Where is that?
Even 9A says so, my lord. Mhm. Communication of orders. Hello? 9A, this book at page 542, my lord.
But right now, today, what do you all want? You want the entire writ to be heard?
Lordship, because I'm retiring on 39. They did
Or
not
you want this
reinstate-
IA?
Lordship, they did not reinstate me in violation of
But
Honorable
right now,
Court's
what
order.
is listed? The IA?
The entire matter has been listed. Pleadings complete, and what they have done, concession has been made by my learned friend before this honorable court. That process of reinstatement is on, my lord. When the matter was so situated, I have come across an order whereby my order of suspension is extended. And as show cause notice.
Can the
also
entire
listed.
writ petition be heard, Mr. Gogoi? Are you agreeable?
I have a slight difficulty in that issue, my lord, because we are confined to a very narrow issue in an IA, my lord. Whether this order remains or is modified.
Rule 9, please show me rule 9.
9. Communication of orders.
1 second, I'm not getting it.
Lordship. Lordship will be getting after rule. This is 9A, my new book. Ekon ase niki?
Yes. I
9A.
think, huh?
9A. After minor penalties, major penalties, minor,
A procedure for imposing penalty,
then.
then it's coming major penalty. Where is
Yes.
9?
My lord, there's a new book, page number 542.
Yeah, I think it is not in this book.
I'm giving away this.
Come নিদিয়ে কিয়? কালিৰখনত আছিল নে? সেইখন ক'ত গ'ল? সেইখনৰ আনাই লওক, নতুনখন নালাগে, ইয়াত নাই।
Communication of orders, minor.
Yes.
Orders made by the disciplinary authority shall be communicated to the government servant, who shall also be supplied with a copy of the report of the inquiry, if any, held by the disciplinary authority, and a copy its findings on its charge, or where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority and a statement of the findings of the disciplinary authority, together with brief reasons for its disagreements, if any, with the findings of the inquiring authority, unless they have already been supplied to him, and also a copy of advice, if any, given by the commission, and where the disciplinary authority has not accepted the advice of commission, a brief statement of the reasons for such non-acceptance. Nothing, my lord. Notes of disagreement, report of the inquiry. Now they have furnished the petition of IA, my lord.
Yes.
Lordship.
I am not allowing, but I can fix it for hearing in the next week. The entire writ, if you all are ready. I am dismissing it right out. In the interlocutory application. Heard MSB Bhuya, Learned Senior Counsel, assisted by Mr. A. Talukdar, Learned Counsel for the, IA, no? Then it will be D. Gogoi, right? Heard Mr. D. Gogoi, Learned Counsel, appearing for the applicant. Also heard Mr. A. Chalia, Learned Counsel, appearing for
Finance Department.
your respondent.
Yes, sir.
Then before him, MSB Bhuya and Senior Counsel, assisted by so-and-so. After that, A. Chalia, respondent number?
Respondent number 4.
4. Anybody else? TKS Barua? Okay. By way of this interlocutory application, comma, the applicant is seeking vacation of
Yes. No.
interim stay order dated 10/4/2025 passed by this court in the connected writ petition IWPC number 2027 of 2025. Operating portion of the order dated 10/4/2025 reads as under. A2, A. Huh? It is name. Mr. D. Gogoi, learned counsel, appearing for the applicant upon being asked, has fairly conceded that the report of the first inquiry officer was not furnished to the petitioner before taking the decision of disagreeing the findings of the such inquiry officer. Stop. Rule 9A reads as under. Reading of the aforesaid, it appears that there is a prima facie case made out by the petitioner in the writ petition. Accordingly, this court does not find any reason to interfere with the interim stay granted earlier by this court by order dated so and so. I accordingly stands rejected. Yes, writ petition, when do you want it disposed of? Next Tuesday? Tuesday?
Yes, today as it may.
In fact, my lord, now.
I am not, you
One-
said you have
Yes.
difficulty.
Thursday, this Thursday, can it be?
This Thursday, that is
Yes.
tomorrow.
In fact, now one read is infructuous because, or maybe through the IO also, I have placed the inquiry report. Petitioner is private.
You see, Mr. Counsel,
3-4-7 goes.
Mr. Counsel, those writ petitions are still alive. We
Yes.
shall take a call when
Yes,
we hear those
3-4-7
writ
is-
petitions.
My lord.
All right.
Next week.
Whether that would be sufficient or not, just annexing with the writ
My lord.
petition, that is also an issue.
But that is
So,
the.
we will
determine
We
which
will look
elements.
into it.
Yes.
We'll look into it. Please give a date.
Lordship, then on Monday, yes, Tuesday. Tuesday,
Tuesday.
my lord.
My lord.
Lordship, what would be my fate, my lord, because fate
We'll
of
see what happens. You'll get all the benefit.
if interim order to continue.
Obliged, my lord.
Interim order to continue. I really appreciate the fairness.
Yes,
we
yes.
put all
Interim
the-
order accordingly
Some issues,
continues. Huh?
some prayers we have to press on behalf of the clients. my lord. Obliged.
You are officers of the court
Yes,
and it is appreciated.
Obliged. Interim to continue, lordship. Obliged. What was that?
It may not be divided. Miss Bhuya, which is in the main?
Oh, in both the cases, interim
Okay,
orders are
okay.
operating.
That is main gita ditiba. Ar jot koba Tuesday listing that likhiba. Interim order passed earlier shall cut till the next date of listing.
In this case, your lordship,
Yes,
I was
Mr.
serving-
Theory.
I was appointed as a Sahayak, your lordship. Your lordship.
As a?
As a Sahayak in the Assam Assam
Yes.
Power Distribution Company Limited, your lordship. Lordship, may kindly peruse page 75. This was the order at the division bench, your lordship. I'm reading from para 4, page 75. Another opposite circumstance, we direct the respondent APTCA to conduct a verification exercise of all the persons who were appointed to the post of Sahayak, and if it is found that if any of them had submitted his or her requisite essential certificates, documents after the last date of submission of application.
One second.
Yes, your lordship.
So your challenge is to this order 3725
Yes, your lordship.
by which R4 came to a finding that the petitioner who is serving as lineman under so and so is liable to be terminated from service. Yeah, the termination is under challenge.
Yes, your lordship. Because as per the advertisement, your lordship, it was very categorically stated that the certificate has to be signed by an authority, your lordship.
And that was not done.
That was not done. But the certificate is a genuine certificate, your lordship.
Only thing, it was not signed.
It was not countersigned in my.
Now, in the advertisement, anything to suggest that non-furnishing of these certificates, it will become, your application shall be not considered
Yes, your
ineligible. That is there.
Yeah, that is there. That is
Where-
evident they have-
The affidavit, let's straight go to the advertisement.
Yes, your lordship, may kindly peruse page page 41, your lordship. Page 40, the chart, page 41.
Yes.
Down below, education qualification, your lordship, may kindly see. The
Yes.
heading, education qualification. Had a lordship got it.
Yes, yes.
SLC pass provided temporary workers engaged in any power utility who have rendered service for not less than minimum period of 3 years are allowed one-time relaxation for this recruitment only on educational qualification from HLC pass to class 8 standard pass. However, they will have to submit certificate regarding their engagement for 3 years from concerned assistant general manager. Your lordship may kindly note concerned assistant general manager. Now, your lordship may kindly peruse the certificates, your lordship, that I had submitted at page 48 and page
Submit,
49.
however, they have to submit certificate regarding their engagement for 3 years from concerned assistant general manager.
Manager, your lordship. The certificates, your lordship, I had
One
annexed.
second. Then how to apply? And non-furnishing is also given.
No, your lordship, it is not given. It only states about this, that they will have to submit certificate regarding their engagement for 3 years from concerned
There
assistant.
must be a clause somewhere saying only from eligible. Applications are invited in this so and so for period of so and so. Penny.
My lord, in respect of item number, my lord, 31 and 32, my lord, we have to file affidavit and reply, my lord.
Why are you not saying it? Then
And for the item number 30, my lord, I got this affidavit on reply half an hour ago.
but otherwise, Mr. Deori, you don't seem to have any case.
Your lordship, but your lordship.
Eligibility of candidates.
Yes, your lord.
Following two categories of candidates are eligible to apply.
Yes, your lord.
Page 40 it is mentioned.
Exactly.
Right?
Yes.
1, 2, category A, category B.
B.
Now for category B, you are under category B.
B, your lordship.
Now for that, the educational qualification says HSLC passed, provided that temporary workers engaged in any so-and-so who have so-and-so period of 3 years are allowed one-time relaxation for the recruitment only on education qualification from HSLC pass to class 7 standard. That means for 7 also you are allowed.
8.
However, they will have to submit certificate regarding their engagement for 3 years from concerned assistant general manager.
Which we
Now,
done.
now, where is that certificate?
Page 48 and page 49, your lord.
Page?
48 and page 49. Your lordship, may kindly peruse 48.
This is to certify. Now, this is what is wrong here?
Is in this certificate also may down below says sub-divisional manager Agomoni Electrical Subdivision has signed this certificate. And it was not signed by the assistant general manager. The next certificate, your lordship, page 49, it is issued by the subdivisional engineer Agomoni Electrical Subdivision saying authority, and it was countersigned by the assistant general manager Dhubri Electrical Division APDCL. The first certificate doesn't contain that.
But this 44 for the second certificate was submitted.
Yes, both the certificates were submitted, lordship. And thereafter, I was appointed. I've been working for the last 11 years. I was promoted. After that, they are now trying to.
That how can you do?
After the division bench order, my lord, they were like personally called 2 times, my lord.
Anyway, then I was thinking it could be, but it requires a full-fledged hearing.
Yes, yes.
I'll admit it and fix it for hearing.
Yes,
Here,
your
so the pleadings are complete.
Yes, your lordship.
It heard Mr. T. Deori, Learned Counsel, appear 81st to Diba, in WPC 3955. Heard Mr. T. Deori, Learned Counsel, appearing for the writ petitioner. Also heard Mr. W. Ahmed, Learned Counsel, appearing for
The APDCL.
for the APDCL, respondent APDCL, and Mr. C.K.S. Barwa, Learned Government Counsel for the state respondent. It appears that pleadings are complete. The matter requires full-fledged hearing. Admit no formal notice as parties are represented through the respective councils. Yes, hearing in the month of November. List for hearing in the month of November 2025 on any date to be fixed by the registry. Other 2 cases list along with so-and-so. In the meantime, the petitioner are at liberty to file rejoinder if so advised against the affidavit in opposition filed by the respondent APDCL. Correct?
There is an interim in my case.
in the three,
Only, on the.
go take the interim, if any, shall continue till the next date of listing.
I'm really.
It plays lordship. Respondent number, private respondent number already appeared, madam.
Yes.
Pertains to compassionate family pension, madam.
Also, here the case is that this thing, the Dickies, he was being promoted from Lot Mandam to Kanungo in the district of Lordship.
Affidavits,
Lordship, we have received the instructions, but
file it.
I think I need to get some updated because these instructions.
So file it. We will not give you time to procure the up-to-date instructions and then again time to
Yes, sir.
file affidavit.
Let me file.
Heard Mr. Heard Mr.
Yeah,
K.R. Patgiri, Learned Counsel for the petitioner. Also heard Mr. C.K. Barua, Learned Government Counsel, and Miss B. Soren, Learned standing for revenue.
private respondent number 8, madam.
For respondent number 8 and Mr. D. as doctor for Standing Council Revenue. Standing Council Revenue and MS. So and so on behalf of Mr. R.K. Talukdar, Learned Standing Council, Accountant General. Stop. Mr. Barua, so and so submit that instructions though have been received in the matter. However, the same is not sufficient for filing the return and accordingly seeks further time to obtain full information, full instruction and thereafter submit the return. Relist in view of this, relist after 3 weeks on a date to be fixed by the registry. In the meantime, the remaining respondents are also shall also file their respective returns if so advised.
My lord, the husband of the petitioner died January 2025.
Yes.
File.
Till date, my lord. The date may be fixed, my lord. After
Okay,
application, my lord.
next.
Obliged.
Yes, Mr. Barua, Mr. Chalia.
Item number 35, Lordship, we have communicated to the department, Lordship. We are seeking one opportunity to file a affidavit, Lordship. We are waiting.
Similar issue passed by this honorable coordinate bench, my lord. Last occasion,
Yeah, why am I not getting it?
No, Lordship, we are just waiting for the department's instruction, Lordship.
You give him a call, the
yes,
department
no, Lord,
concerned, give
yes,
the officer
we have-
concerned a call, get your instruction on the phone.
Yes, Lordship.
How much time it takes nowadays?
Waiting.
You have all the devices.
No, Lordship,
Huh?
the petitioner is praying for the Lordship. Is the registration, Lordship. So that process, Lordship, I just seek.
All right, when do you want it?
Immediately after the vacation, Lordship, in the week.
regarding my lord, denial of the registration of the
Yes,
pharmacist by
Lordship,
the.
that is why I'm
Council.
just claiming, Lordship.
All are same.
Immediately after the vacation, we'll have our instruction, Lordship.
Let him get it, Mr. Barua.
All similar is already decided. by
Where
the-
is that?
Yes, my annex, my
Page?
page, my lord, 30 and my lord. Sorry, 21 page. Paragraph, my lord, to page 24.
Paragraph?
Page 24, second paragraph, my lord. Having acquired the eligibility for being registered as pharmacist, the petition number so and so submitted their respective application before Assam Pharmacy Code 2020 along with the requisite documents prescribed format. While the petitioner number has submitted similar application so and so, so and so. However, such registration was not granted to them by Assam Pharmacy Council and no formal information was issued to the petitioner here. This is the issue, my lord. On inquiry, petitioner could come together that they were being denied such register Assam Pharmacy Council on the ground that they had not passed certain subject in their respective higher secondary course, according they were held ineligible. So that is the main issue, my lord. And last, my lord, paragraph 22, my lord, page 33, my lord. Their objection is that, my lord, paragraph 22, page 33, my lord, paragraph 22. The objection raised with regard to the registration petition at pharmacy.
You have also not the.
One subject I am taking guess in the high secondary. Already I am completed my diploma, my lord. Petitioner Pharmacy by Assam Pharmacy Council present proceeding also effect the Educational Regulation 91 Pharmacy Council mandate that for admission into diploma in pharmacy candidate has to be passed subject physics, chemistry, biology, mathematics individually in their higher secondary examination. It is projected that petitioner had not passed in all subject mentioned above. Accordingly, they were held to be ineligible, having their name registered, their contention, my lord. And operative portion, my lord, para 29, my lord. Page 37. Para 29, page 37, 29 and 30. Accordingly, this court is of the considered view that peculiar facts and circumstances arise in present matter. The petitioner herein have to be held to be eligible for having their respective name registered as pharmacists based on diploma in pharmacy course awarded to them by Srimanto Sankardev so-and-so. In view of conclusion drawn herein above, register come Secretary Assam Pharmacy Council and or any other competent authority Assam Pharmacy is hereby directed to process the application submitted by the petitioner herein.
Mr. Machalia, you see, this decision is already there.
Yes, Lordship.
You haven't challenged this decision.
No, Lordship.
Right?
Yes.
Now, since your affidavit has not come forward and even the petitioner has not, no communication has been given to the petitioner by the respondent as why their registration applications has not been processed or rejected if so.
Basically.
So that is also not there, correct? So you find out
Yes,
what is the reason. You get that information. I'm having this matter on Monday. You get that information. Because if suppose similarly for,
Also there, Lordship. That is
you see, Mr. Chalya, you just get that
Yes,
information.
Lordship.
Because if it is covered by this judgment, there's no point of keeping
Lordship.
this matter to
Lordship.
post puja vacation.
Yes.
You see, you have to treat the petitioners fairly also. It is not necessary that the moment an application for registration is put, you have to grant it.
Yes.
But nonetheless, you have to consider, you have to deal, you have to let the petitioner know the fate of those applications. You can't be sitting silent over their applications. The grievance, what necessitated the petitioners to approach this writ court? Because nothing has been heard from you, correct? That can't go on.
Yes, Lordship.
And now also sufficient time has gone.
Yes, Lordship.
So get that information.
Monday, Lordship.
Heard Mr. N. Barua, Learned Counsel for the petitioner, also heard Mr. A. Chalga, Learned Standing Counsel, Health.
Yes, Lordship.
So and so. On the next date of listing, Mr. A. Chalya shall specifically obtain instruction as to the status of the application submitted by the petitioners for registering for registration. But you have said this. How do you know? In your case, you know that the respondents refused his registration.
Yes, when I come to know my law and code para 6, page 6, man.
No, they are cut it, yeah. That Mr. N. Bora, Learned Counsel for the petitioner, has submitted that the application filed by the petitioner, one petitioner for registration before the Assam Pharmacy Council has been refused on the grounds that the petitioner had failed physics theory in higher secondary. He further submits that the issue involved in this writ petition is covered by the coordinate bench of this court in WPC 6394/2024 dated 11/6/2025. Though by order dated 22/8/2025, the instant matter was directed to be listed today to enable the Learned Standing Counsel Health to get instructions whether the instant case is a covered matter as per the aforesaid judgment of the coordinate bench. However, today when the matter is called, Mr. A. Chalya seeks for further accommodation in the matter. since the issue, no, considering the urgency canvassed by the learned counsel appearing for the petitioner, relist on such and such date, on which date Mr. H. Halia shall positively place the instructions as called earlier by this court by order dated 22/8/2025, and also apprise the court in the event. No, that's all. I think that is all that you need to say. If it's covered, say it's covered. If it's not covered, you say why it's not covered. And in the event, the instruction is that the petitioner's case is not squarely covered by the judgment of this coordinate bench, the reasons so.
Mark. Item number 11.
Yes.
My lord, that case perhaps my lord has remembered that is my lord suspension matter, my lord, regarding that my lord review is required to be made within 90 days. My lord, I have my lord, a compilation of such judgment I have already submitted, my lord.
Oh. I have also prepared on compilation.
Here, suspension was on 14/10/2024.
My lord.
Review was done on 22/1/2025.
2020.
That is admittedly after the 90 days.
90 days. Correct, 90 days.
This is under the state of here Deepak Mali, because it's a CCS.
My lord.
Deepak Mali is under the CCS. huh?
No, my lord, the Deepak Mali, my lord, the Ajay Kumar Chodhary, Deepak Mali, that their judgment has been subsequently by this honorable court, my lord, in read appeal number 114, my lord, that to both the judgments were followed. And observations were made in my lord, following the judgment rendered in my lord, Deepak Mali and Ajay Chodhary.
Where is this judgment number?
Ajay Kumar Chodhary.
No. WA 114.
My lord. That is on my lord, judgment number 4, my lord, serial number 4.
Here you are in what post?
My lord, I'm a Mondal, my lord, Lat Mondal. Lat Mondal.
Oh, this is that lot Mondal.
Lot Mondal, my lord. My lord, with all due respect, my lord, before going to the judgment, may I just, my lord, refer this, my lord, the section 6, my lord, section 6 of the, my lord, Assam Service Manual General Rules, my lord.
Yes.
Only two, my lord, that there is, my lord, two categories of suspension, my lord, only two, my lord, refer.
Yes, because I have forgotten, so you can refresh.
My lord, the section, my lord, of 533 page number, my lord, this book manual. 533, my lord. Section 6, my lord, from the Assam Service Discipline and Appeal Rule 1964.
Section 6.
Section 6, my lord.
I think the page is different. Section 6 is chapter 6, right?
My lord, my lord. Yes, my lord.
Suspension and departmental proceedings.
No, my lord. Section 6, 3, 5. No,
No,
my lord, section, my lord, section 6.
Wait, just 1 second.
It is on page 429, my lord.
Yes,
My lord of 5, thereafter, my lord 6.
yes,
6, my lord suspension.
yes.
My lord, subclause 1, appointing authority or any authority to which it is subordinate or any other authority empowered by the governor in that behalf may place a government servant suspension where a disciplinary proceeding against him is contemplated or is pending, or where a case against him is respect of any criminal offense involving moral turpitude is under investigation or trial. My lord, here is two categories of suspension order, my lord. One for pending royal of disciplinary proceeding, my lord, and other, my lord, when my lord, some charges are pending against any incumbent. These are two categories. In my case, my lord, in my case, my lord, even though petitioner was arrested, my lord, the order was not passed on the ground of arrest. If your lordship will go to my suspension order,
What do you want to show from here?
there is two categories of suspension order. Suspension order can be passed, my lord, two categories.
Where a disciplinary proceeding is pending.
Yes, yes, ma'am.
Or where, in the opinion of the authority aforesaid,
Yes.
he has engaged himself in activities prejudicial to the interest or the security of the state.
Yes, ma'am.
Or where a case against him in respect of any criminal offense
involving
is under investigation,
investigation.
inquiry, or trial.
Trial.
Provided that where the order of suspension is made by an authority lower than so and so, such authority shall forthwith report to the appointment in which the order was made. Yes.
Yes.
Now, in your case, which is applicable?
My lord, my lord, I have been arrested, but in lordship will file, my lord, my case is not, my lord, my suspension order, my lord, was passed, my lord, pending roll of suspension, pending roll of departmental proceeding, my lord.
There was a departmental proceeding
Departmental
as well.
proceeding. If your lordship will go through my suspension order, my lord will file.
Okay.
Thereafter, my lord, that my lord, the contention, my lord, following the my lord, the principle laid down in Deepak Mali and in Ajay Kumar Chaudhary and Deepak Mali, that had, my lord, that the suspension order has to be reviewed within the stipulated period of 90 days.
Yes.
And Deepak Mali case, my lord, it has been very apparently written that any subsequent review done after expiry of 90 days is not valid, my lord. And that was, my lord, will find in the, my lord, writ appeal 114/2022. That is, my lord, in my compilation.
Yes, I have it. Tell me the paragraph.
Paragraph, my lord. Well, paragraph is, my lord, 12. My lord, paragraph is my lord 12 and 13. That is on page 8, my lord.
Paragraph?
Paragraph 12, my lord. Writ appeal, serial number 4, writ appeal 114/2022. Paragraph 12.
Yes.
My lord, may I read this, my lord?
Yes, please.
My lord, on paragraph 12, my lord, in the case of Union of India and versus Deepak Mali reported in so and so, the apex court had interpreted sub-rule 6 of rule 10 of the rules 1995 held that an order of suspension would not survive under the period of 90 days unless it was extended after review. In the case, it was observed that since no review was held in a period of 90 days, nor was there any order of extension of the suspension issued within the said period. Subsequent review and extension of the order of the suspension would not sustain the order, which had already been invalid after expiry of 90 days from the date of suspension. Thereafter, my lord, on paragraph 13, from careful analysis of the above decision of Supreme Court, clause is that unless review is held within 90 days, an order of suspension, including one issued due to the detention of an employee in custody or 48 hours, would not survive, nor can such an order be granted fresh lease of life by carrying out a review after expiry of period of 90 days. In view of the said law laid down in so and so case, it is axiomatic that the order of suspension dated hearing the my lord, petitioner was suspended on 7/12/2019 had lapsed after the expiry of 90 days due to want of review of the same by the disciplinary authority. So we therefore, we therefore find ourselves in agreement with the findings recorded by the learned single judge. That order has been set aside by the learned single judge, passed in this passed by the department.
Yes.
Now there are some other judgments are there regarding this 90 days period. I will clarify. There's some coordinate benches have passed and the division benches also passed. Their contention is that my service is that I have been arrested and even though they are trying to substantiate that my suspension is deemed suspension. It is not deemed suspension. They are saying that basing on a judgment of passed by the Lanat Rafid Ali case, namely Rafid Ali, that the 90 days period has to be computed from the date of releasing of the bail or from the intimation to the government. That is their contention. Now, this issue has already been clarified by the division bench in Recapil and Recapil's case, and that has been followed by the single benches, some other coordinate both of this honorable court. I am annexing all those judgment in the compilation wherein the fact is very clear. In this in the Ajay Kumar Chaudhary case, wherein this honorable court in Recapil's case, honorable case for the first time has given the observation that the Ajay Kumar Chaudhary is applicable, but in case of suspension, which is for pending drawal of departmental proceeding, and also in cases of deemed suspension. So, wherein
No, but in this division bench judgment also, Rekibuddin Ahmed is
yes, madam.
Is noted. Correct. So this division bench judgment which you have relied, that is clear.
Yes.
That is in support. It
Yes.
supports you. It's
Yes,
in your favor.
Yes, madam. I'm
Isn't it?
favor. Yes, madam.
So, Mr. Datta,
Yes, that's it.
it appeared that 90 days
90
period is required.
Yes.
Basically, Ajit Kumar and Recruitment. Basically, the division bench deal with that. The 6.1 and 6.2 will be applicable, or the schedule will be applicable, 6.1 and 6.2. There is no dispute. Thereafter, one judgment we have furnished, that is Rafid Ali. Rafid Ali Ahmed.
I'll come to you.
Mal.
I'll come to you. Rafael Ali, yes.
Page 20 onward, yes, sir. In para 20.
Para 20.
Para 20.
It starts at what page?
20.
No,
Rafid Ali
that's
start from page 20.
judgment starts from page 20.
Losses.
This is all okay. Yes.
Relevant para 20 logic. May I read logic? A very pertinent question therefore arises.
This is a coordinate bench. There is a division bench.
Coordinate logic. That has
There is a division bench judgment.
that 90 days. That is there is no dispute that 90 days within 90 days.
Yeah, but what do you want to show from this bench?
Logic. There is in this judgment. This the honorable single justice held that the 90 days will be counted from the date of intimation.
Paragraph?
Para 20 logic. A very pertinent question therefore arises as to form which period the direction in para 21 of the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary shall apply in the case of deemed suspension. It would be seen that the judgment of the division bench of this court in the case of Recruitment, however, with due respect, did not deal with this question. An insight to the same can be unrevealed from the proviso to Rule 6.2 of the 1964 rule. The proviso speaks upon the following condition upon which the appointing authority may vacate the suspension order when government servant is released on bail or is not otherwise in custody or imprisonment. There, one lawsuit, where the detention is made on account of any charge not connected with the government servant's position, or where the detention is likely to embarrass the government or government servant to discharge of his duties. 3. Where the charge does not involve moral turpitude. However, upon relying the judgment of the Supreme Court in Ajay Kumar Chaudhary and the judgment of the division bench of this court in the case of Recruitment Ahmed, his fourth condition can be called out. That is where the memorandum of charge of the charge is not served upon the delinquent officer employed within 3 months from the date of release on bail or release from any custody or imprisonment, and if memorandum of charge public charge sheet is served, a reasoned order must be passed for extension suspension order. Now, the question therefore arises that when the above mentioned conditions can be taken into consideration by the appointing authority. In the opinion of this court, the condition above noted can only be taken into consideration when the delinquent officer, public employee, brings to the fact that he or she has been released on bail or otherwise not in any custody or imprisonment to the appointing authority who has the power to vacate the suspension order. This is the finding of this court.
One second, one second. Now, the question therefore arises that when the above mentioned conditions can be taken into consideration. In the opinion of this court, the condition above noted can only be taken into consideration when the delinquent employee brings the fact that she has been released on bail or otherwise not in any custody or imprisonment to the appointing authority who has the power to vacate the suspension order.
That intimation has to be given because
Because otherwise, where will it be served?
where will it be served? That is the
Suppose
purpose.
he's inside
It's
the
jail.
custody,
Lordship.
then unless he is out, serving will not be sufficient.
Lordship.
So is it, but that is only in a situation where the memorandum of charges is not served. So is this your case that here?
Here, Lordship, the petitioner has intimated to the
No, but when did the charge sheet was charged to the petitioner?
Within 90 days after getting intimation by the authorities, they have served the.
Now tell me one thing. The initial 90 days perhaps expires on 14/1/25, correct?
Yes.
Because the suspension is of 14/10/24. Correct, Mr. Datta? Now, when did you receive the intimation?
We have received intimation on 10/12/2024.
10/12/24. That he is been released on that bail has been granted. And then when did you serve?
Then on 18/12/2024 we have served. 18/12/2024.
That means within 90 days.
From the date of intimation.
These are mentioned in which paragraphs? These dates are mentioned in which paragraph?
My
reply, yes.
Affidavit, it start from 92, para 11. Let's see.
Page
92, para 11. Right?
The pages actually have been again recorrected. No. This is an affidavit. But I just want to see the affidavit also once.
Affidavit starts from page 88, Lordship. And relevant para.
Yes. So at the time he was suspended, that time he was already inside the custody. Where do I get those in the petition, Ms. Bhattacharjee?
In the writ petition, page 39, Lordship, is the initial suspension order, Lordship.
Page
39. Annex 4, Lordship. Order dated 14/10/2024.
Do you have a better copy of this suspension? Page 39. It's not very legible in my copy. Is there any other extra copy? Now, where does it show that he is in custody?
Lord, I'm saying, my lord, that my suspension order is, my lord, for pending denial of, my lord,
Correct.
departmental proceeding. Not on the grounds that, my lord,
Where does it say?
no,
It says pending drawal of departmental
Exactly, ma'am.
proceeding against him.
not on the ground of arrest, not a deemed suspension.
That report is necessary by doing conversion.
Huh?
Lordship, first paragraph, where is the report of Circle Officer, Bagbar Revenue Circle, bearing number so-and-so dated 9/10/2024, that Rahim Ali so-and-so of Bagbar Revenue Circle, now working as Corporator Revenue Circle, grossly neglected his duty by doing conversion of AP land.
That's the
AP to
allegation.
PP,
Yes,
yes,
negligence
without
of duty.
verification of actual fill.
That is the allegation.
Yes,
On basis of
Lordship.
a, on basis of a report.
And
submitted.
basis of this misconduct of his duties, he has been
That's right.
suspended.
So, but this doesn't say that he is under custody or he is arrested.
Admittedly, he has been arrested, Lordship. That is perhaps
No,
45. Lordship.
Mr. I just want a document or paragraph where it says that he is in custody at that time. Where do you get that?
Para 40. 42, Lordship.
Para?
42, bail order.
Bail order, page 35.
42.
Oh, in the read petition, page 35.
No, 42.
Huh?
42.
35 लिखा है, so this-
Page 42, Lordship.
Page?
42 is the bail order.
You have a 35 meeting.
Page 42 is list of documents.
No, Lordship, it is 35.
I cannot hear both the councils together. One of you
35.
kindly address the court. Yes,
Something wrong in his copy.
no problem. Just one of you now refer to the correct pages
Yes,
and give me the
correct page
page.
35, Lordship. Order dated 28/10/20.
Yes, I got it.
Wrong copy has been served, Lordship. That is why. Wrong copy has been served using a surplus.
Sorry?
The presentation is not proper. In my copy,
Oh, sure, sure.
there.
But where do I get his date of arrest? In this order. Date of arrest.
Well, he's arrested on
Hmm?
10/10, my lord. He's
Huh?
my lord, he's arrested on 10/10/2024. That is, my lord will
10/10?
10/10/2024.
Arrested.
Arrested, my lord.
And bail on 28/10.
Yes, my lord. 2010.
Where do I get it?
I have filed an additional subsequent affidavit, my lord, 106 page number, my lord.
So you see on that means on 14/10 when you were suspended,
My lord.
you were under arrest.
Not arrest.
Right? And you
Under custody, pardon.
under custody and you were released only on 28.
No, no, I'm not under custody. Yes, ma'am.
30.
28.
28/10.
10.
24.
I can raise this.
And you gave your intimation on 10/12.
10/12, my lord.
Lordship, even if he got the bail order on 28/10, he was released, page 38,
Yes.
Lordship, on 30/10.
30/10.
Bail bond, this, the
Submit.
order is there, Lordship.
Page 38. This is 30/10/24. Release. Yes, what do you have to say to this?
Yes, my lord. My lord, these issues were already, my lord, raised by, my lord, by, and this issue is already settled, my lord, by some, my lord, judgment of this honorable, my lord.
To this particular
Yes, yes,
issue.
lord, very, it has been.
Because
heavy, my lord,
here we are only concerned with one thing.
Yes, my lord.
That because this court condition that the charge sheet has to be served within the within the currency of the 90 days period is not given in the rules, right? This is something which the Ajay Chaudhry's
Yes, yes.
case has held.
Yes.
Now, the word is served.
Yes, my lord.
Now the question is, if you are inside inside the jail,
No, my lord.
if you are detained,
correct.
then where is the occasion of serving you?
My lord.
Right?
My lord is correct.
Now could be another thing that you are out and they have not extended,
Yes.
and those can be a different thing.
My lord.
Those are different things.
My,
But once you are out, unless you give the intimation, they will not know.
my lord.
They will not know.
My lord.
That is why the coordinate bench have said that
My,
this issue was never dealt with by the division bench or the apex court in Ajay Chaudhary, that service.
yes, my lord. That has been dealt, my lord.
In the event
Yes,
the
I will-
person concerned
Yes.
is inside the custody.
My lord.
So show me
My lord.
if it has been done.
First of all, my lord, that the question is, my lord, only the my lord, whether the authority is reviewing or not within the stipulated period of 90 days. My lord, as for assumption, my lord, my lord, without going into my lord, the judgments, my lord, that when an authority is passed an order of review, my lord, the authority themselves pass and they are very much aware. My lord, if somebody is behind the bar within that, my lord, within that for that 90 days period, then authority can pass an order reviewing that the person is behind bar, then his order was reviewed.
See, all that is all right. Now the fact that
I'm coming, my lord.
you see now that there is a
No, I'm coming,
coordinate.
my lord. That has
See,
been-
now you have to understand that since there is a coordinate bench
My lord,
finding,
I'm coming, my lord. That
especially on this point, right?
That judgment has
So,
to distinguish, my lord.
so where is that? Give me
My
that.
lord, lordship, may just for a moment, my lord, that I have
Distinguished by a division bench.
my lord, three or single bench, three or four judges, and my lord, the division bench also, my lord, very clearly says.
Show me those judgments.
My lord, will find the similar, my lord, a cases, my lord, all the cases are, my lord, fact and circumstances, all, my lord, where in all the cases are, my lord, deemed suspension. But my lord, in none of the cases, while computing the 90 days, my lord, the date has not been, my lord, computed
No,
from the date of.
see, in that situation, what happened is that that particular perception was not perceived.
Perceived.
Now that is sub-silential.
No, my lord, that
So
is have been
there-
very.
no, you have to show me a
Yes, yes, that I am
decision
showing, my lord. My
where
lord,
this
statement-
question, the issue was perceived in the mind of the court, and there is a finding to that effect.
My lord, first of all, my lord-
Otherwise, those are sub-silent.
Yes, my
So
lord.
you
My lord-
please show me a decision.
Yes, yes, my lord. Lordship, that the serial number, my lord, of 5, my judgment, my lord, 7530.
Yes.
7530, repetition number 2023.
Yes, Vinod Kumar Payang.
My lord.
Yes.
My lord, on page 5, my lord.
Yes.
My lord, page 5. Vinod Kumar Payang. Page 5, my lord, on the second para. Second para, my lord. Following the decision of the Supreme Court. My lord has got it.
Yes.
Following the decision of the Supreme Court in case of Ajay Kumar Chaudhary Supra and this court in Recruitment, another division bench, this court held that the case of so-and-so, an order of deemed suspension under Rule 6.2 of the rule so-and-so would automatically lapse after expiry of 90 days from the date of order of the suspension. My lord, it is deemed suspension. My lord, following the two principles, my lord, it has been clearly said that, my lord, it is expired after expiry of the 90 days from the date of passing of the order, from the date of suspension, not from the date of releasing of bail or intimation to the department. It is not reviewed within 90 days from the date of issuance of the order. The observation made in paragraph 13 in the case of Ajit Chunwal is reproduced here below. My lord, that is, my lord, Ajit Chunwal division bench judgment, my lord. This para 13 of the division bench is, my lord, referred herein. Para 13, my lord. My lord, got it?
1 second. Para?
Para 13, my lord, on which, my lord, page 5, just I have read the paragraph, my lord. Paras are not there.
Yes, Ajit Sonowal.
Ajit Chunwal, my lord. The 13, para number 13 of the Ajit Chunwal retable 114 has been referred herein, my lord. It has been very clearly, my lord, stated. Observation is there, my lord, that from the para 13, my lord. May I read, my lord?
Yes.
My lord, that from the careful analysis of the above decisions of the Supreme Court, what follows is that unless review is held within 90 days, an order of suspension, including one issued due to the detention of an employee in custody, 48 hours would not survive, nor can such an order be granted fresh lease of life by carrying out a review after expiry of period of 90 days. In view of the laid down law laid down in the case of Deepak Mali and Ajay Kumar Chaudhary Supra, it is accommodated that order of suspension that is so and so has left. Malat here in the order of suspension has been left, that is computed from the date of passing of the order.
So is it now that there are two contrary views of the coordinate benches?
Perhaps this judgment
let me
passed
finish.
before.
It's all right. Huh?
This judgment has been passed before coming to.
And I know, you see, before or after doesn't mean, you see,
My lord is
coordinate benches judgments have to be either if it has to be followed, right? If there is some difficult one situation could emerge where another view is perceived, then it has to be placed before a larger bench.
Yes, ma'am.
Now it appears what is the projection which is coming from both sides is appearing that there are two views of coordinate benches.
Coordinate benches, my lord.
One view is that since 90 days as terms of so and so, irrespective whether
Section
one is in custody or not,
yes.
it will run from the date the suspension is done, and within expiry of
Yes.
before the expiry, it has to be reviewed.
Reviewed, my lord.
This is one view.
That is only one judge, one case.
And in that situation, they have in the facts of a case where this was argued. So it cannot be said that it is sub silential.
And that in some after passing of the rapidly, my lord, the learned single basis pass another.
I think, Mr. Doctor,
That's it.
you have a relook of these decisions once again. I can have this matter fixed Monday or Friday if you are agree if you are say, because if there is a contrary view, then I think the appropriate course would be to place it before a larger bench.
That's it. After other surgery, another Supreme judgment has been come passed by Honorable Supreme Court Lordship. That has been said, Lordship. I have annexed paragraph 27. My compulsion, Lordship. Start from paragraph 27.
Yes.
50 plus 50.
Yes.
Yes, sir. This same issue has been raised in the Supreme Court Lordship. Now,
Yes.
court's finding is to start from paragraph 50, Lordship.
Page?
Page 42.
Yes.
Paragraph 50 onward, Lordship. Paragraph 50. Insofar as prolonged suspension of respondent number 1 is concerned, the respondent number 1 has relied the judgment of this court in the case of Ajay Kumar Chaudhary Supra and State of Tamil Nadu, represented by the Secretary to the Government of Assam versus Pramod Kumar, IPS, and another. So far as judgment of this court, the case of Ajay Kumar Chaudhary is concerned, though this court has deprecated the protected period of suspension and repeated renewal thereof, in the facts of the said case, this court found that since the appellant therein was served with charge-sheet, the direction issued in the said case may not be relevant to him any longer. Insofar as judgment of this court in the case of Pramod Kumar is concerned, this court is observed that there cannot be any dispute regarding the power or jurisdiction of this court of the state government for continuing the first respondent under suspension pending criminal trial. There is no doubt that allegations made against the first respondent are serious in nature. However, the point is whether the continued suspension of the first respondent for prolonged period is justified. In the said case, the respondent number 1 therein was suspended for more than 6 years. This court found that no useful purpose would be served by continuing the respondent number 1 therein under suspension any longer. We find that in the present case, it is the respondent number 1 who, though called upon to participate in the development proceedings, has on his own chosen not to participate therein. It is the respondent number 1 who has objected to initiation of the development proceeding by the commissioner on the ground of
relevant.
Yes,
how it is to be computed.
Last third line, maybe this is the ratio of the judgment. In any case, we find that the issue of prolonged suspension would be taken care by directing the departmental proceeding to be completed within a stipulated period. But suspension of
in the facts of this case, You see, Mr. Counsel, what this court is now concerned with the, no, in the context where a person is in the custody at the time of suspension. And unless and until, because here the question is from which date you will say the charge sheet has been served. The issue is of the serving of the charge sheet. Now, if whether that's a serving of, because admittedly in the case in hand, the charge sheet has been served. But it has not been served within the currency of the 90 days period. Admittedly, in this 90 days period, you were inside the custody.
Yes.
Admittedly, not for 24 hours, not for 42 hours, like the other coordinate bench judgment. The entire period of 90 days, you were in the custody. Only after that you had come out and you have intimated.
Yes.
And they have given it.
There's
Correct?
Lordship.
So that is why I'm saying this judgment doesn't help you to that point.
continuation.
I am right now not saying that this should be this or this should be that. But you see, I cannot be ignoring the coordinate bench's judgments also.
Lordship, I have a small submission, Lord. Lordship, I just want to point out the date of suspension, initial suspension. This was, Lordship, in page 39 of the writ petition.
That
This is
doesn't
on
mention.
14/10/24. And Lordship, the show cause, the very next page, page 40, is on 18/12. This is well within the 90 days stipulated period, Lordship.
Which
And
show cause?
the show.
There's a memorandum of such.
Yes, Lordship.
I'm not on there.
This is Lordship.
Memorandum of charges has been
Memorandum of charges has been
18/12.
served. But
1812, yes.
Wait, let me submit.
1812, yes.
Lordship. So this is well within the 90 days period, Lordship.
No, 19 days.
So they have
90
reviewed
days
my order.
period.
Correct, because it
Yes,
expired
and
on
Lordship,
14.
And Lordship, that
You're right, you're right.
two citations there, they are just relying, Lordship, Deepak Mali and Ajay Chaudhary. Both of these are on CCA rule, Lordship, where there is stipulation of 90 days, even in review also.
So
If it's
now the issue is that it has not extended.
This memorandum, Lordship also has decided on, I think on Monday, Lordship, on 4/2/2020, office memorandum is there, wherein there was a direction from this honorable court to formulate some rules, because our rules speak something else, Lordship. Show cause must be within 90 days. If it is not done, Lordship, then the recent order has to be passed. If the charge sheet is filed, Lordship, then the review is within 6 months. This
Wait,
stipulation is
now
Lordship.
just
So
you
this
see,
is not under challenge.
Ms. Saji, now I am a bit confused. What is the ground of challenge? What is challenge here? 90 days period or the extension period?
My lord, my order has not been reviewed within the stipulated period of 90 days.
90 days.
There is a, my lord, that my order has suspension order has to be reviewed within the stipulated of 90 days. They have, my lord, reviewed, but my lord, after expiry of the 90 days.
Yes.
Now,
When was the review done?
my lord, that is a review done on, my lord. My petition. Earlier, my lord, they were, my lord, they are.
When was the review done? Give me that date.
Yes, my lord. I'm coming. My lord, on 22, my lord, review on 22/1/2025. That is that my lord will find on page 79.
22/1?
22/1/2025. page 79, my lord will find.
79.
79.
So this review was done after
Expiry of
14/1/25.
Yes, my lord.
And but if suppose we take this
Office
we take it from the date of no, then also it will not come, because this review has to be done in within the lapse of the 90 days. Correct? From the date of suspension.
That is the fact that has been clarified. And now they are only they are contending that, my lord, that 90 days has to be completed from the.
Now this which is the judgment that you are relying on this point?
My lord. That on 7530, my lord. serial number, that judgment. Vinod Kumar Panke, 7530, madam. On compilation, in my compilation, it is on
Yes.
serial 5, serial number 5, madam.
Yes,
Page number 5, madam.
yes,
Page number 5, madam, second para.
yes,
Start from second para. Flowing the decision, my lord, got it?
yes,
Following the decision of the Supreme Court in case of Ajay Kumar Chaudhary Supra and the court in Rekibuddin Ahmed Supra, another division bench of this court held that the case of Ajit Chunwal Supra that an order of deemed suspension, that is for arrest under Rule 6 subsection 2 of the rules of 1964 would automatically lapse after expiry of 90 days from the date of the order of suspension. It has been, it will, the currency of the suspension order will lose its effect within that from
yes.
after expiry of 9 days, and that is has to be from the date of suspension, not from the date of releasing on bail or that to the intimation to the government.
Right.
The paragraph 30 has been referred herein of this original case. For careful analysis of the above decisions of the Supreme Court, what follows is that unless a review is held within 90 days, an order of suspension, including one issued due to the detention of an employee in custody for 48 hours, would not survive, nor can such an order be granted fresh lease of life by carrying out a review after expiry of period of 90 days. In view of the laid down in the case of Deepak Mali Supra and Ajay Kumar Chaudhary, it is axiomatic that the order of suspension dated so and so had lapsed after the expiry of 90 days due to want of review of the same by the disciplinary authority. That is from the date of suspension, 7/12/2019. That is the date of suspension. Thereafter, on the
Yes.
bottom parameter, as not the decision referred in the so and so as noted above, Mr. Nayak and so has argued that since the petitioner has intimated the department about his release on bail on so and so, hence the period of 90 days is in this case ought to be computed in the effect from the said date, bearing in mind the mandate of paragraph 2.7 of the Rule 6064. It would be relevant to note herein that in the case of Ajay Chunwal, the division bench's category held that period of 90 days is to be counted with effect from the date of order of the suspension. This order has already been, this issue has already been raised. Thereafter, honorable court, the following the principles of this apex court and all, that has been in the same case. In this case,
Which is in your compilation, where will I find Ajit Sonal's case?
Ajit Chunwal case, my lord.
Have you given?
Yes, my lord. I'm giving, my lord. On serial number 4, my lord.
Serial number 4.
4, my lord. That is 114.
That is the Ajit Sonawal, na?
Yes, my lord. Ajit Chunwal. He's a respondent. Government has preferred this, my lord, this application.
Okay.
Ajit Chunwal on paragraph 13, my lord.
All right, all right.
It is on page 8, my lord, of the judgment, bottom paragraph, my lord.
Yes.
My lord, 13. From careful analysis.
No, I've read it.
Yes, yes, my lord.
Yes.
My
Yes.
lord, yes, my lord. On
Page
paragraph
5, we have already read that part.
Yes, my lord, already read. My lord.
Yes.
Paragraph 13.
Yes.
From the careful analysis of the above decisions of the Supreme Court, what follows is that
No, you've already replaced
yes,
it.
yes, my lord. This paragraph is referred in that judgment.
All right, you've already read that.
My lord, I have already read. My lord, that is very much clear. There's my lord, another my lord judgment, another my lord that of in my compilation, my lord.
Yes.
In compilation 447, my lord, on serial number 6, my lord.
Yes.
That is Nepal Chandra Mandal. That has been, my lord. In this case, my lord, all the my lord, the fact and circumstances of are similar, my lord.
Yes.
Here in my lord, the para number 9.
Yes.
My lord. As
Yes.
indicated above, division bench of this court was held that case of deemed suspension rule so and so would also have to be treated with the same rigorous as laid down in the case of Ajay Chaudhary and Ajay Chaudhary. My lord, herein, my lord, the Ajay Chaudhary is applicable in both the cases, my lord. My lord, that apparently, my lord, the same similar set of principle will be applicable because it is, my lord, applicable in case of, my lord, pending trial and deemed suspension. Thereafter, my lord, in this case, my lord, here also, my lord, even though, my lord, he has been the petitioner arrested, but his suspension order was now not passed on that on the ground that he has been arrested. It is, my lord, passed on the ground of pending trial of departmental proceeding. My lord, will 10 page 10 in the para 10 in the instant case, the order of suspension is of 13/7/2023. Though the aforesaid order does not reveal that it has been passed an order on the grounds of the petitioner belong arrested on the previous day. It is the arrest of and detention of the petitioner which has triggered the authorities to pass the aforesaid order of suspension. Nonetheless, since the order of suspension states that it has been passed pending withdrawal of a departmental proceeding, this court will proceed with the assumption that the suspension is not a deemed suspension. So in my case, similar situation. I have been arrested, but my suspension order was not passed on the ground that I have been arrested, and herein the court interfered, and that the period of 90 days is computed from the date of date of suspension, not from
Yes.
the date of release. And thereafter, last. Perhaps I'm bothering you, Lord.
No, I'm just thinking.
My lord.
Yes, go ahead.
My lord. There, my lord, and economy interfere. My lord, on paragraph 12, my lord.
You are doing absolutely fine, Mr. Counsel.
My lord.
Yes.
My lord, on 12, my lord.
Yes.
As already observed above, as per the law laid down by the Honorable Supreme Court and also by the division bench of this court, the review done for extending the suspension, which is beyond the period of 90 days, cannot save the employer from the legal obligations cast upon them. The order of suspension dated so-and-so 13/7/2023 is accordingly interfered with and the petitioner is directed to be reinstated in service. The posting order should be issued within a period of 15 days from the date of furnishing a certified copy of this order. So it is set aside, and the 90 days is computed from the date of
Suspension.
Date of suspension. Herein also, my lord, the petitioner was arrested, and the petition. This is the petition serving. He was arrested on 12/7/2022 in connection. So subsequently, my lord, he has been, my lord, he subsequently thereafter he has been suspended. My lord, it is a case of deemed suspension. My lord, even though, my lord, cannot be said, my lord, that it is deemed suspension. Even though I have been arrested, my lord, a suspension order was passed on the ground of pending withdrawal of departmental.
What do you mean by deemed suspension?
Deemed suspension, my lord, when a person is, my lord, that the section 6 subsection 2 deemed suspension, when a person is, my lord, suspended when he has any under the custody or arrested in connection with any criminal allegation.
That is the deemed
suspension.
But your suspension order
No.
doesn't say that.
Exactly, my lord. Prima facie that, my lord, the suspension order, my lord, prima facie reveals it on a
Withdrawal of disciplinary proceedings.
Exactly, my lord. And on basis of a complaint submitted by the circle officer itself, there is some misconduct on basis of a.
No, but in either in any of the three conditions,
My lord.
that 90 days period is same, isn't it?
Same, my lord.
Whether it is under A, B, C, that is not material.
No,
If there is a suspension order,
yeah,
then it has to be
reviewed from
reviewed.
within stipulated period of 90 days.
Unless disciplinary proceedings are concluded
Yes,
within
same,
that currency.
Exactly. And my lord, Ajay Kumar Chaudhary's case, my lord, the Honorable Court in my lord Recruitment's case had, my lord.
Now here, there is another rule which has also, I think, which has now given a 3 months.
Yes, my lord. That is,
Which is that?
3 months, my lord, the rule 6(2).
Rule
That I have
6.
just, my lord, referred on the very beginning, my lord.
Yes, where is that?
That is, my lord, on page 239, perhaps. On
Just mark it in this book.
That is, my lord.
That is 3 months, na?
My lord, 3 months is not there.
What is the period? Just.
No mention of
No, no,
period,
no, no.
lordship.
So for the period.
That's why the.
Period is not there.
No, that
Yes,
is right. That
lordship.
OM is
That's
3
the-
months.
That's to cover up this.
OM
and
is
on
3
the-
months.
Yes. on
Where
the
is
direction
the
of this,
OM
lordship.
part of this book?
No, this is not part of this book.
My lord, so far as the my lord, so far as the OM is concerned, my lord.
Where is the OM?
OM
It has been-
reference.
74 nice compilation book.
You have given it in your compilation.
Lordship got it, lordship. This is.
It's all right, Ms. Bhattaji, take your seat. Let him first finish it.
Okay.
Otherwise, it becomes very
Yes,
confusing.
yes, yes, lord.
Yes,
My lord,
to it from the OM. Do you have a copy of the OM?
my lord, I have a copy of the. My lord.
Served within 3 months of suspension. A reasoned order must be passed for the extension of the suspension wherever necessary. After issuance of charge sheet, the senior most secretary shall undertake a review within 6 months. I think I have authored one judgment on this.
On Monday.
Do you, do you have a copy of that? Or the party's name, please indicate.
King of Islam. 417.
Yes, you may conclude your
My lord,
argument.
my lord, my lord, so far as this memorandum is concerned, my lord, it has been issued by the, my lord, Chief Secretary of the, my lord, Personnel Department, perhaps. Chief Secretary of the Personnel Department, my lord. Here, my lord, only does memorandums in, it has been, my lord, explain how to deal with the, my lord, persons who has been suspended. Now, my lord, this memorandum is, my lord, it is, so far, my lord, my knowledge is concerned, my lord. This memorandum is not issued by the governor. It is only an executive instruction. It is not law. This executive instruction cannot override or cannot override a subtle proposition of law.
Now, where under the law, this time period is given, which is the provision in the act or the rules.
My lord, act is silent.
Correct. Therefore,
But,
the
my lord, so
executive
far as the-
instructions. You see, because the act is silent, the executive instructions has come. Correct.
But it
So
cannot override the law, my lord.
what? That is why I'm asking.
My lord.
Where is that law? The apex court decision will come to it later. But first of all, under the statute, is there anything given?
My lord,
It is not there.
stated,
Now,
my lord,
now you
in
see,
the-
if you see the heading of the OM,
My lord.
read the heading of the OM.
The Honorable Court Guwahati, it is ordered dated. The Honorable Court Guwahati, it is ordered dated. So and so. In a service of read petition, the
In a
case
series.
the lead case being so and so has directed to issue a notification indicating the law laid down by the Honorable Supreme Court in so and so.
Ajay Kumar Chaudhary.
Chaudhary.
So you see, because of a direction from a division bench, that was say because of a decision with the council, this OM has been framed in view of the decision rendered by the coordinate bench of this court in a series of writ petitions, the lit case of which being WPC 6465 of 2017, wherein directions were given to the state government to frame guidelines in terms of the decision of Ajay Kumar Chaudhary. And this is what has been framed. They are doing this. Now, if you keep this OM in mind, it appears that your case has been reviewed within 6 months.
No, my lord.
No, I am saying, don't say no. You may give your arguments, Mr. Counsel, but it looks that time frame. If you go by the time frame, you may have a different perception. Of course, you can place your perception. Ultimately, it is for the court to accept your perception or not and to give a finding, right? But it appears that the review was done on 22/1/2025.
My lord.
So this appears to be within the 6 months, which is provided in this paragraph after issuance of. You read the whole OM once. Because you have not challenged this OM, mind you.
My lord, I have not challenged.
Correct.
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 But so far, my
So you see,
this is
in a recent judgment of mine, I have also dealt the similar argument coming from that side.
my lord.
It's paisa nahi.
This charge sheet is from the delinquent employee before expiry of one period from the date of the sentence order. That suspension 3 months.
Warnerjit, তুমি এবাৰ তাত চাই ল'বা কাৰণ তুমি এতিয়ালৈকে একো পোৱা নাইতো কোনে কেনেকে পাইছে দুটামান তিনিটা ডিছপ'জেলছ হৈছে কাৰণে ছেকেণ্ড হ'ল তেনেকে
My lord, even though
লাগিলে তুমি আগতে আহি তাৰপিছত ফ্ৰী হৈ ল'ব পাৰা
my lord, even though it has my lord, it has not been very clearly stated in the memorandum, it is to be reviewed within the my lord 90 days. But virtually, it is indicating in the memorandum also that the currency of the suspension order could not, my lord, extend beyond 90 days, my lord. Beyond 90 days.
In a copy taken of DDoc.
On the next page, my lord, I have found
Huh?
they sell of the memorandum, my lord, second paragraph. It is
Yes.
there. They shall also ensure that the currency of suspension order should not extend beyond 3 months.
Where?
On the second para,
Second para
middle of the second
main
para.
lordship. Fifth line,
Which line?
fourth line.
They shall also, yes.
Yes, no. They shall also ensure that the currency of the suspension order should not extend
beyond 3 months.
3 months.
If
in the
within
period of
this
memorandum
period, the
charges is not
memorandum of
served,
charge
the
sheet is
mem-
not served. In
yes,
your case,
yes,
it has
sir.
been
But
charged.
after, my lord,
Yes.
if the memorandum of charge sheet is served
Within 3
3
months,
of suspension,
a reasoned order
order
must
be passed for extension of the
suspension wherever necessary.
Exactly, my lord.
Then you read the next.
That is, my lord. That is, my lord.
Then read.
The officer proposing
No.
suspension
Shall also
ensure that the charges are framed
frame
and
and
submitted
submitted
to
to
the
within
authority within
After
2 weeks from
issuance.
later. After issuance of memorandum of charge sheet, the senior most secretaries
Shall undertake a review within 6 months
within 6
as regards the desirability to further continue with the
on the
suspension
yes.
order.
My lord is correct. That Ajay Kumar Chaudhary and Deepak Malis is also some instruction is there. But first review has to be done within the period of stipulated period, my lord. Thereafter, the
Only if the
first-
charge sheet is not given.
My lord,
No, in your case, you see, you
No,
have
my
to
lord.
understand.
My lord
You
is correct.
Mr.
My
Counsel,
lord.
please don't say that word no.
My lord,
You
I
cannot say
apologize.
no to the
I apologize.
court. You say your submission, no problem. One thing what comes out is that in your case,
My lord.
within the 90 days period, admittedly, the charge sheet has been
My lord,
served.
served, my lord.
However, the issue is now whether it was
Reviewed or-
extended
reviewed
within
or
that
not?
90 days or
Extended,
not.
extended.
Because now when you count 90 days from the initial date of
Yes, my
suspension,
lord is correct.
that extension is not within the 90
Exactly.
days, right?
Otherwise,
It wa-
memorandum of charge.
Correct. Now, going by this OM,
My lord.
because Ajay Kumar Chaudhary, what has been said is that you have to, first of all, you cannot keep the entire object is to ensure that
expedite.
someone is not kept in suspension for a longer
Ex-
period. That is the main object. Now, in keeping that, Miss Bhattacharya, please kindly can you have take your seat? You will get your turn. Why are you interrupting when the court is interacting with the petitioner's counsel while he's arguing? So it is with that context, right? Now, for that, Ajay Chaudhary have said that the 90 days is the maximum period of suspension unless until you give him the charge sheet and thereafter you extend if necessary with a reasoned order, right? Now, there could be a situation where the 90 days current time period expires on a particular date. Till then, no charge sheet has been given. Now, if that be so, obviously there has to be an extension before the expiry of the 90 days. But in a situation, suppose you listen to the court, you come up with your answer later on, but try and understand because you have to convince the court. So understand what is going on in the mind of the court.
Exactly, my lord.
But suppose within the 90 days, the charge sheet is given. Okay, extension not given. But going by the OM, they have given you now the extension also. And that extension is within 6 months. The OM is not under challenge
Man.
in this court. Right? And the OM is referring to the decisions passed by the coordinate bench and Ajay Kumar Chaudhary.
No, my lord, almost not.
No, it is referring in that first paragraph. We'll resume after the break. You think about it and it will deduct
My lord.
a judgment of which has been passed by this court where this aspect has gone into. Just have a look at it. We'll take it up after the break. You have a look at it because it's an important issue that is
Absolutely.
coming up. So it cannot be just hurriedly decided.
Yes, yes.
I have not decided anything. So I'm open to all the arguments coming from both sides.
Exactly.
So for that we have to have some sort of interaction. Otherwise, how will it be? So only for that purpose I'm interacting with you.
My lord. my lord.
আৰু এটা আছিল হে সেইটো আৰু এটা টুট আছিল তো Yes, did you go through that?
My lord, I have gone through this, my lord, the memorandum, my lord. Just very briefly, I would like to make a submission, my lord.
Yes.
My lord, as my lord, regarding two aspects of this, my lord, memorandum, whether the department has complied with this, my lord, the conditions laid down in the memorandum or not, and my lord, the legal validity of the memorandum, my lord.
Yes.
My lord, after going through this memorandum, I have found one thing, lord,
Yes.
that, my lord, the review order has to be passed by the senior most secretaries of the department, my lord.
Yes.
But in my case, the review order has been passed by the director of land record.
Okay.
He is not the senior most secretary, my lord.
Okay.
And my lord, another thing is there, my lord.
Yes.
May I just, my
Yes,
lord,
yes.
refer the memorandum.
Yes.
That is in their affidavit, my lord.
Just 1 second, huh?
Fine.
Yes.
So the memorandum is in my lord, their affidavit. It is on page number 124, my lord, continuous page number.
Page
Page 124.
124.
my lord.
212.
212.
There are so many pages.
My lord.
Is this your reply?
No, my lord, that is, that affidavit, my lord, an additional affidavit filed by the, my lord, state respondent, director of land record. my lord. Continuous page number 124. Additional affidavit.
There's no 124 only. This is an additional affidavit.
My lord, additional affidavit, my lord.
Okay. Now tell me the internal page of the additional affidavit or paragraph number.
Paragraph number, my lord. No, but I'm referring the memorandum, my lord.
Is this a 4/2/2020?
My lord, 4/2/2020, my lord.
Yes.
Yes. My lord, the second para,
Yes.
my lord, it is therefore directed.
This is the same OM.
Same.
Yes.
Yes, yes.
Yes.
That is same one.
Yes.
It is therefore directed at all the senior most secretaries of all the departments shall ensure that the memorandum of charges is served on the delinquent. Thereafter, my lord, on paragraph number 4, madam. All after issuance of memorandum of charge sheet, the senior most secretaries shall undertake a review within 6 months as regards the desirability to further continue with the suspension order. That, my lord,
Yes.
as per this memorandum, the review order has to be passed by the senior most secretary of the department. Herein, my lord, the commissioner and secretary is the senior most, my lord, the secretary of the department. And my lord, review order was passed by the, my lord, director of land record, not by the commissioner.
Where do we get that? Where do I get that review?
My lord, will
page?
file, my lord, in my writ petition 80, my lord.
Page 79.
Page, my lord, in my writ petition, that my lord review order, yes, my lord. 79.
Yes. Director of
Director
Land.
of land records. Not by the commissioner.
Yes. Anything else?
On the bottom, my lord, 1, 2, 3, some, my lord.
Yes, I saw.
Yes, my lord.
Yes.
And my lord, as per the office memorandum also, my lord, whatever the, my lord, review order they have passed, they will have to, my lord, communicate with the personal department. No any communication has been made by them because they are.
To the?
My lord, it has to.
Communicated to?
To the personal department, my lord. As part of memorandum, my lord.
Okay.
My lord, no communication.
The very technical points you are raising. Yes.
So far.
Yes.
Yes.
All right, they have not.
They,
I appreciate your submissions, your hard work, but at some point, you see, you have to be also fair.
my,
They have not sent it to the personal, all right. How are you prejudiced?
no, my lord, that there is a my lord, observation.
All right.
Yes, they have to, my lord,
That's all right. They have not done it.
Yes,
Yes. This is an equity court.
my lord.
Yes.
I'm only referring to whatever the content.
That's okay.
My lord. And my lord, so far the requirement of 90 days is. It can
You have already argued.
But only one aspect, just I will like to lordship, your lordship's kind attention as regards it. So far as the my lord, the judgment of judiciary, our High Court in Recruitment Name's case, my lord, has given an explanations and observations. That is just for a moment, my lord. That on page 16, that is my lord rendered by our High Court. Yet further in that instead, it is seen that the order of suspension is also on account of pending law of disciplinary proceeding within this case. Periodic review within 3 months is otherwise held to be mandatory.
All right.
Division case.
All right.
Case
Anything more?
has given the observations and my lord, lastly that I have already given, and my lord, last my lord, in my compilation only one judgment, my lord, serial number 7320 for that judgment, both are by that single bench, but the Rafet Ali has been differentiated.
All right.
Following the principles laid down in this about that.
Okay.
That-
Yes.
I will just, my lord, lastly, so far as the legal validity of this, my lord, the notification is concerned.
That you have not challenged.
No, my lord, I'm not challenged, but
And I have already dealt with it. You have any grievance, you
No,
can
but
take
yes.
that issue before the other remedy.
My lord,
You have not challenged.
but I'm not submitting this judgment on that particular aspect. My lord, there is my lord. Just like to just place this judgment before your lordship. Paragraph 42, my lord.
Yes.
Paragraph 42, my lord, this judgment, my lord, the said circular, in a similarly situated case, my lord, the department has had issued a notification that is not by the government by sub-executive instruction. The state circular letter has not been issued by the state in exercise of its power under Article 162 of the Constitution of India. It is not stated therein that the decision has been taken by the cabinet or any authority authorized in this behalf in terms of the Article 163 subclause 3 of the Constitution of India. It is stated that a circular letter being an administrative instruction is not a law within the meaning of Article 13 of the Indian Constitution.
All right,
My
noted.
lord, only just I want to substantiate, my lord, this is an executive instruction.
All right, I have noted.
Yes, my lord,
Yes.
cannot offer that.
This goes with your other volume then.
My lord, my lord.
Hey, আর একটা clip দিব, এটা ইয়াত আছে।
Summarily, that is, my lord, that is summarily legal.
একটা clip did you? Yes. Only one reply. There is an argument that the review is not by the senior most secretaries, which your OM says. What do you have to say to that?
Lordship, this depends, Lordship. The senior most secretaries, they will be held responsible if it is not done within their department, Lordship. So
Let's read that again. The OM.
OM Lordship, first, second, third, fourth, fifth para, Lordship.
After issuance of memorandum of charge sheet, the senior most secretaries shall undertake a review within 6 months as regards its desirability to further continue with the suspension order. So,
Senior most, then the
Ms.
next,
Bhattacharjee,
Lordship.
you see the argument from that side is
Lordship.
that under this OM, it is the senior most secretary who has been given the empowered
Yes,
to undertake the exercise of review.
Lordship.
And the time frame is 6 months.
Yes,
In the
Lordship.
case in hand, it is some, what is that officer?
Director of Land Records.
Director of Land Records who
Lordship.
has done this review. This is the argument.
Yes, Lordship.
Now, it could be that they're the senior most secretary. Who's the senior most secretary? I don't know. So you have to get back on this. Or otherwise, what is, because otherwise, how do we deal with this this particular aspect?
Director of Land Records being the appointing authority of the, because the cadre also has to be looked
So,
into,
but
Lordship.
here it is not said that the appointing authority will do it. there is, then you see, you might, your argument may be there is no senior most secretaries in that lot mandal for lot mandal. There has to be commissioner and secretary,
This
land
is the
revenue.
Land Revenue Department, Lordship, and the Director of Land Records being the highest authority. That means they are the appointing authority, Lordship.
Appointing authority understood, but
Yes,
here
Lordship.
the office
And the- as well
memorandum
as
doesn't
the
say.
disciplinary authority also, Lordship.
You see, the OM doesn't say the disciplinary authority will undertake. The OM doesn't say the appointing authority will undertake. It is your OM.
Yes, Lordship.
Just do not
Then the-
say something just for the sake of saying it. Say it with some responsibility, Ms. Bhattacharjee. You want some clarification, you obtain it. That is another thing.
Okay, Lordship.
Because you see, it is very clear.
Okay, Lordship.
Senior most secretaries. In the given case, it is not the senior most
Senior most
secretary.
secretary. Okay, Lordship.
So I want an explanation to
Yes,
that.
Lordship. We'll get the clarification.
Otherwise, the arguments are
Yes,
closed.
Lordship.
No further arguments. I'm making it
Only
clear.
this particular
Only
point.
this particular
Lordship.
point. Tomorrow.
Tomorrow,
At
yes,
2?
Lordship. Yes, Lordship.
Tomorrow.
Every order has been, appointment order or any order has been.
Mr. Datta, please understand. If this court has to confidence of this court, that is why this court has given you both the
Yes,
opportunity. Find it out, come up
Tomorrow,
with.
Lordship.
Yes, tomorrow I will forget otherwise.
Lordship.
So many matters are, the councils I can see, they've been impatiently waiting while I was investing judicial time in this matter with the hope that I'll dispose it of today. But that is not happening, it seems. So at least tomorrow,
Tomorrow, Lordship.
otherwise I'll forget. Mr. Heard Mr. P.K. Datta, Learned Counsel, sorry, so-and-so Learned Counsel appearing for the petitioner, also heard M.S. Bhattacharjee, Learned Additional Senior Government Advocate for the State Respondent, and Mr. S. Datta, Learned Standing Counsel Revenue by both sides. However, on a limited query, the matter is posted tomorrow at 2 o'clock. To enable the state respondents to apprise this court as regards the issue that the impugned review order of the suspension is issued by the
Director of Land Record and Survey.
so and so. Page 79 not paija by 2. এইখিনি ভালকে থৈ দিয়ক এইটো ইয়াৰ লগত দি দিব দেই অ'কে
Time being item number 3.
Your Lordship. My lord, this is regarding a transfer order. My lord, and I
আৰু
had.
এটা যে হিয়াৰিং কৰি আছিলো এই ছেত্ৰী matter ক'ত গ'ল that was the matter why are you not calling that matter that yes because there was one matter which almost I have heard it was only on one point I kept it at 2 that's why I was inquiring because I thought I can give that judgment
Taken up first, my lord, I have.
no problem what is this IA you have to hear
Yes, my
you are
lord,
pressing for hearing what is the IA
I is regarding the, my lord, for vacating the interim order that has been passed by this honorable court in favor of the petitioner. My lordship takes up this into that I, my lord, I'd like to praise the orders that have been passed by this honorable court.
IA is for vacating
Vacating the interim order.
you have filed the IA and what was the nature of the interim order
My lord, the
Chaudhary, then let me deal with that other matter because that matter, the hearing was already completed. It is only one judgment Mr. Chetri wanted to show from the Supreme Court. So only on that. Otherwise,
or maybe, my lord, your lordship may fix it for final hearing because vacating.
when do you want it?
As my learned friend, my lord.
If everyone agrees,
Only thing is, my lord.
when do you want it, Miss Borwa?
Only point is that, Lordship, my respondent number 3 is not getting any salary for 2 months.
No, then you wait for some time. Give that other matter. Call 7.
Item number 7.
Yes, did you find that decision you wanted to rely?
Yes, madam.
Yes.
Judgment is on. First thing, my lord,
Just give me that decision. please.
yes.
That should have been the first. That is the why the matter is kept at 2. Why are you taking so much time to find that decision,
There
Mr.
are so many
Chetri?
decisions.
But this matter was kept at 2 only for
Yes.
one decision after Debabrata Tiwari
That-
by the apex court, which you
Yes,
said.
yes.
Please give me that decision.
After the this honorable court, this Devadatta Tiwari, there are so many cases, my lord.
Yes, the first case is Govinda
Janardhan.
Janardhan. Paragraph.
Paragraph, Lordship will find Govinda Janardhan, para 4, 6, and 9. That was decided on 6/11/2023. 4, my lord. There are 4 grounds recorded by the High Court in the paragraph 4 of the impeachment judgment for rejecting the writ petition filed by the appellant. The said 4 grounds are as follows. It is 15 years past the demise of the father. For 15 years, the family has survived. The sister of the petitioner has also got married. The petitioner has also got married and is working as a laborer. The fact that the appellant's sister has got married has obviously nothing to do with the grant of compassionate appointment to the appellant. Secondly, the appellant is not having regular employment and is working as a laborer. Thirdly, the appellant could apply only after he attained the age of majority. Now 6. It is very unfortunate that the concerned respondent raised a contention before the High Court that the family of the appellant has survived for 15 years after the death of the appellant's father. He is not entitled to compassionate appointment. In our view, considering the concept of welfare state, the respondent number 3 and 5 ought not to have raised such a contention, especially when the appellant is making both ends meet by working as a laborer. Thus, none of the 4 grounds mentioned above are available to the respondent number 3 and 5. And accordingly, 7, the learned counsel for the appearing respondent of 3-5 submitted that initially the appellant's mother applied for compassionate appointment and thereafter the appellant applied for substitutions. On this point, in paragraph 3 of the impeachment judgment, the High Court has decided against the state government.
All right, next case, which
now-
paragraph?
now-
First case I've read, Mr.
Yes,
Chetri. After the
2025.
next case, paragraph.
That is paragraph 2025 0 Supreme
Give me the
SC.
paragraph.
Yes. Paragraph 25, 26, 27, and 28.
25, 26, and 27.
25, 26, 27, and 28. This Kannada being married. The first married lot.
Yes.
It would be easier to understand for.
Yes, yes.
The first sub issue 25 million. In relation to the lapse of time, since we are in the delay issue, lapse of time since the respondent's father passed away, it has been in excess of 2 decades. It does not require anyone to put on a magnifying glass here to assess the time that has been taken for the application of the respondent for compassionate appointment to be finally decided. The parties have reached the 3rd tier in the 2nd round. On the foremost factor for appointment on compassionate ground, is that the same should be offered at the earliest unless appointment is made soon after the need to mitigate the hardship arises tiding over the immediate financial crisis owing to sudden premature and ultimate untimely death of the deceased employee. 2, medical incapacitation resulting in the employee's unfitness to continue in service, for which benevolence is shown by offering an appointment may not exist, and thereby the very object of such appointment could stand frustrated. 26. More often than not, claims for compensatory appointment reach the high courts or even this court after consuming substantial time. The ordinary rule of litigation is that right to relief should be decided by reference to the date on which the suitor entered the portals of the court. The relief that the suitor is entitled in law could still be denied in equity on account of subsequent and intervening events, that is, events between the date of commencement of the litigation and the date of decision. However, law is well settled that such relief may not be denied solely on ground of time lost.
Solely on account of time.
Solely on account of time lost in prosecuting proceedings in judicial or quasi-judicial forum for no fault of the suitor. Which is Raj Singh versus State of Assam versus State of UP 2003 1 SCC 726. It would therefore not be prudent or wise to reject a claim only because of the time taken by the courts to decide the issue before it. Number 27, my lord. Lapse of time, however, be a major factor for denying compensation appointment, where the claim is lost belatedly beyond 1 year, my lord. A presumption is legitimately drawn in cases of claims lost belatedly that the family of the deceased incapacitated employee is not in immediate need of financial assistance. However, what would be reasonable time would largely depend on the policy scheme for the compensation appointment under consideration. If any time limit has been prescribed for making an application and the claimant applies within such period, lapse of time cannot be assigned as a ground for rejection. These are the factors where delay only can be considered that if within the time period prescribed in the policy, the application was not submitted, then that will be the delay. Otherwise not, my lord. In such cases, this case, my lord, these petitioners is of 2001, my lord. 2001, the father of the petitioner died. But even then, in such cases also, the relief was granted to the petitioner.
Yes, next case,
And
paragraph.
That's 27, my lord.
Next case, para 27.
Next case. Now, my lord,
No,
I'm relying on 1966 0 Supreme SC.
That's not here. There are two more cases which have been, there are 4 cases that have been given. First two you have already relied. What is this 240 INSC 538? Which paragraph in this?
Which one, lordship? A bank. Bank of India. This one, lordship, decided on 34th.
Yes. Which paragraph of this?
Lordship, here. On filing intra-court appeal by bank, the High Court referred the scheme dated 17/3/1999 and analyzed the support of clause 10(4) of the letter of the Bank of India in board meeting dated 2002. In reference thereto, the court observed that the deceased was neither punished with major penalty nor such penalty was in contemplation against him prior to his death. It is said that this is regarding disciplinary.
All right.
And
right.
the compensatory appointment was denied.
Very well. I've seen it. The other case of of this court, 2018, paragraph.
2018 of this honorable court, Lordship will find. Here it is. High Court. That is 4-5, that is 2018 2 GLT. Oh, no.
Yes, 2
Yes,
GLT, yes.
2 GLT 390.
Yes, paragraph.
4, 5, 6, 7, my lord.
4.
5, 6, 7. No, 5.
All right.
There is a 8 years delay, and for 8 years delay, the writ petition was dismissed. Married Lordship, it will be.
Yes, yes.
4. At the very outset, we make it clear that this court is not oblivious of the fact that if a family has managed to sustain itself for more than a couple of years, consequent upon the demise, Lordship, firstly 3 years, para 3, during the course of hearing, Ardhar Learned Additional Senior Government Advocate Assam have produced a copy of the minutes of the meeting 11/8/17, the state level committee. The said minutes provides the necessary information with regard to the case of the appellant. It is shown that the case of the appellant pertained to the year 2009, and the state level committee considered his case in the meeting held on 1/4/15 and thereafter on 9/12/15.
But this one is prior to Debabrata Tiwari.
Debabrata Tiwari, but only delay part, 8 years delay part.
That let us not unnecessarily go into this, because you see, Debabrata Tiwari has come. Now thereafter, this is okay. I have taken note
Yes.
of it.
Then Lordship,
Because you see, if you start, then too, you will have so many decisions of this court and other courts
yes,
where compassionate appointment
Then-
has been given, even by this court.
in 96.
So I think this will not be required.
And my lord,
Yes.
one more this 1966. I would like to refer before Lordships. 1966 is very important to decide the matter. On this point, my lord, since the rejection order, the rejection was made in 2019, and as per the office memorandum, it has to be communicated to the petitioners, as per the memorandum, my lord, and it has not been communicated. And Lordship knows very well that once the official order is not communicated, meaning thereby it has no force in the eye of law. This full bench,
All right, I have taken note of. You just give me that citation.
this citation, my lord, I am providing.
It's all right. Look, it is as a known proposition of law.
Law.
Order not communicated shall not come into effect.
Yes,
Yes, where you had made an RTI here, right?
yes, RTI.
Where is that?
That, my lord, the Lordship will find in the writ petition. That, my lord, page 47, my lord.
Page?
47.
What?
I'm reading, my lord, this.
No, you don't have to read. I just wanted to see some. You had already placed it in your first round.
Yes. And this query was given, and they have given the answer, my lord. My cause of action arise only in 2024 when I got the minutes of the meeting.
Mr. Gogoi,
Lordship.
this 19 DLC rejection was not communicated?
So my most probably not, your lordship. This was not communicated. This was not communicated. Rejection order.
Then how will he know whether his case has been rejected, not rejected? It's only in 24.
2024.
And where is this annexure? At page 47, the annexure is not there. Mr. Chetri, where is this minutes?
Minutes, sir, lordship.
Annexure 1, it says the required information is enclosed here with annexure.
This I have enclosed as annexure this 45, my lord.
Page 45.
Page 45.
This is not there. Your affidavit is there or not?
Yes, Your Lordship.
So what have you said? And you were showing that it is the mother who has filed
Yes.
for appointment of her son.
Son.
Because her son has already met with an accident and he's disabled.
Yes.
50% disabled, Your Lordship. There's
Now,
that
now the appointment is sought for by whom?
appointment is
By
sought
the petitioner.
By the mother.
No,
No.
petitioner itself.
Who is the petitioner?
The son.
The son.
but the application is done by the mother for her son.
On behalf of the son, because he was the bedridden and under the treatment.
But she has made it. The candidate is Nobojit
Yes.
Bhagwati.
Yes.
Candidates on the application made by mother.
But on that ground, you have not rejected.
We have rejected on the ground, Your Lordship. Now can you see
Which is
that date, page 46.
you have ground. It says that his proposal can be considered as per para 3 of OM so and so dated 1/6/15.
Yes.
What does that OM say?
That says that we have to apply the compensation grounds within a time frame of 1 year.
1
Within
year.
1 year.
Now, within that 1 year,
This 15 is there.
he was incapacitated.
Yes.
But his mother applied.
Mother
Yes.
applied on 19, Your Lordship.
No.
No, mother applied on 5/10/15.
Yes.
The proposal in respect of nominated so and so, the father applicant the applicant applied for compensation upon 6/1/19
This is
as per page
subsequent.
46.
No, I think because I remember Mr. Chetri had shown me the application of the mother is on 5/10/15.
Yes.
Where do you get that date, Mr. Chetri? 5/10/15?
Lordship will find page 27 of my writ petition, Lordship. And page 28 is the vernacular laws.
Page
27 is the translated copy.
27. Yes,
27
yes.
This is
Yes,
translated.
27 is there.
and 28 is the vernacular laws.
Date 5/10/15.
Yes. And
Get a clarification on this. Mr. Gogoi?
Yes, Your Lordship. Though they have submitted an application, they'll get the clarification on this.
Get a clarification on this.
15 here, though, is submitted, rejection is 19.
Because, and also on the subsequent decisions you have taken note.
Yes, Your Lordship, I have taken note.
I have noticed that they have there the Debabrata theory otherwise was not discussed. And those and obviously decisions are contextual. And the coordinated bench of this decision where this specific issue was that appears to be prior to Debabrata theory because there this thing has been taken. It's very otherwise the facts of that coordinate bench is very squarely. It appears to be applicable to the petitioner's case in support of the petitioner's case, but that is prior to Debabrata. And after Debabrata, there are a few more judgments of the apex court where it says that merely because the department takes time in not issuing the, in not either accepting, rejecting, later on, they cannot say that now there has been a delay, therefore it will not come. But this part is again contrary to what has been said in Debabrata theory.
Yes.
There it says for no whosoever's, notwithstanding whosoever's fault. Whenever there is a delay, there shall be no applications of compassionate appointment shall not be maintainable. So you just have a look at this aspect from this perspection which has been placed by Mr. Chetri, and we can have it on another date. But you'll have to look into it and address the court on that. Okay.
Yes.
And the fact that what happened to this application 5/10/15?
There's though
Because you have not referred.
we have not referred, but we have referred to 2019 application.
So What happened to this? Because this is within 1 year.
Yes.
Now you're referring to a subsequent application and saying that doesn't appear to be correct. Then in that case, it can be allowed the petition because you are not referring. Your ground of rejection is not within one year. This date 5/10/15 is within 1 year.
I didn't know 1 year, Lordship. That's true.
Where have you stated about this in Lecture 8 in your reply? What have you said? Hmm? 1 second, I'll come to you. And in the reply also, they have categorically said again in para 5, the deponent strongly denies the fact that the deponent's mother submitted an application along with the documents in the time dated 5/10/15 before the executive engineer PHE on behalf of her son, which was endorsed by the official concerned. Who is R4? Who is R4? Executive Engineer Nagaon Division.
Yes, yes.
That is you.
PHEL.
You have not said anything to this. Yes, Ms. Bhattacharjee, what do you want to say?
I just want to point out page 38 of the writ petition, Lordship.
Page 38.
Lordship. This application by the mother of the petitioner, Lordship. Dated 8/8/2018, Lordship.
They're subsequent.
Lordship, but there is not a single mention that they applied.
That is all right.
This is.
That
their
is all
lordship.
right.
And this is.
Ms.
the-
Bhattacharjee, have you replied to the averments made in the petition? What have you stated about this application? Because in the affidavit filed by R4, they have not said a word. They have not denied.
We have filed, Lordship.
Have you said something? These
Yes,
are court
Lordship.
proceedings. What have you said?
In page 59.
What have you said?
That the assigned states that the executive engineer PhD Nagaon Division submitted the proposal of the petitioner by letter dated 11/7/2019.
That is different. I'm not on all that. It is respondent number 4 who has to say. He has not said.
Yes, Lordship, and paragraph 6 we have specifically stated, Lordship.
Yes, what?
The assigned deponent does not admit the same and states that no application dated 5/10/2015 of the petitioner was received by the district level committee Nagaon from executive engineer.
That is, you have not received from them. Now, if they have not given to you, for that we cannot say they have not given. It is for them to first say. Your role comes later, Ms. Bhattacharjee. You are not the PHE. The claim of the petitioner is not that they have given this letter to you, to the DLC. They are saying it is given to the PHE. PHE doesn't say anything. Affidavits are filed so that you are given a chance to explain. That explanation is not there. Denial is not there. It's a very casual affidavit in opposition by the executive engineer Nagaon Division. Yes, right down. Heard Mr. B. Chetri, learned counsel for the petitioner. Also heard Mr. R.R. Gogoi, learned standing counsel PHE, and M.S. M. Bhattacharjee, learned additional senior government advocate for the state respondents. After hearing the matter for quite some time, it has come to the notice of the court that though the mother of the, right now who has come? The son. Though the mother of the petitioner has submitted an application before the respondent number 4. Before the respondent number 4 on 5/10/2015, which is enclosed as annexure so and so to the writ petition. However, the impugned rejection by the impugned order of the DLC, whereby the claim of the petitioner's appointment on compassionate ground was rejected on the ground of a subsequent by referring to a subsequent application submitted by his mother on the same being time barred. It is surprising that despite receipt of notice, affidavits are being filed before this court in a very casual manner without even denying the contentions raised in the writ petitions. In fact, there is no whisper in the said affidavit as regards the receipt of the application, as regards the status of the application dated 5/10/15 filed by the mother of the petitioner. Since the said application appears to be within the time period prescribed in the OM in question, there is the same is of significance. Let Mr. So-and-so, Mr. R.R. Gogoi, obtain specific instruction in this regard, relist on such and such date. I have narrated everything so that I don't forget. That is the only thing.
That is the only.
Because you see, if you have received that, then you can't say that time barred. And you have not said a word in your affidavit. What is the use of filing affidavits then? Okay, very good, yourself. Yes, when? All right, clipped up. Mr. Chetri, I'm keeping these decisions that you have given, huh?
Yeah, that's okay.
On such and such date. Did you got data?
All right, much obliged.
That be item number 3.
Otherwise, can it be treated as part or matter?
No, no.
No, since
After vacation, I shall forget. Yes.
My lord, since the issue is very small, your worship may my lord take up for final disposal. My lord, they are subject to, because my lord, she was saying that she has not received her salary. I am also not receiving.
The only thing is that today is a miscellaneous day and everyone is waiting.
Well, can I be tomorrow, my lord?
Tomorrow? Rupak, itu kaile lobo project.
Tomorrow 2 o'clock, your worship may fix it at
All
5
right.
o'clock, my lord.
Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. N. Dekal, Learned Counsel for the petitioner. Also heard, this is the IA. So, MS R. Bora, Learned Counsel, appearing for the applicant, and you are also there?
For 1 and 2, the official,
Huh?
for the official response.
Yeah, for the official respondents. And Mr. D. Bora, Borwa, BORH, and Bora for the official respondents. And petitioner Etiakoba. And it is submitted at the bar that it appears that in order to consider the prayer made in the interlocutory application, the entire writ petition is required to be heard. That being so, and pleadings are complete in the writ petition?
They have not, my lord.
It is further submitted by Mr. D. Bora, Learned Government Counsel, that the records are available with him. That being so, relist tomorrow to enable the court to make an endeavor to dispose the entire matter.
My lord, interim order is still today, my lord. So
Interim shall continue till tomorrow.
can it be at
if
2
any.
o'clock tomorrow, my lord?
All right, 2
More or
o'clock.
less.
But with the understanding, tomorrow you are not filing any affidavit. So later don't say that you need time for affidavit. Because you see, the problem is that when I invest time, I expect to deliver. And then at some point today, apparently in all matters, something or the other is going on.
In fact, the court called for the records, my lord, the
Very
record will reveal, my lord. Obliged.
Item number 61. May it please the lordship. My lord, in this case, my lord, we have the petitioner, my lord, he retired in the year 2022 in the month of July.
Item number?
62.
Supplementary. Yes.
So he retired, my lord, on July 2022, my lord. Since then, he was not paid his pensions and other retirement benefit. So, my lord, he has filed his writ petitions, my lord, along challenging another letter of the, my lord, executive engineer, my lord.
Yes.
So, my lord, on last occasions when the lord, this honorable court has heard the matter, my lord, lordship may kindly come to the last order of, my lord, on 7/8/2025, my lord. I will take your lordship to para 9, 10, 11, 12, my lord.
The detailed order.
Yes, my lord. So what is I will go to this order after I will just give the factual background, my lord. May I read, my lord?
Yes.
Para 9, my lord.
One second, just 1 second.
My lord.
The operating portion of this order is which one?
My lord,
9.
Yes, my lord, 9, 10, 11, 12. 10, 12, 10 and 11, my lord.
So provisional pension was
Yes,
given.
provincial pension.
What
and
happened?
other-
Please, Lordship, my senior Mr. Nayak is on legs.
No, but provisional pension is now given or not?
Not given, my lord. Nothing
Why
has been given.
giving?
My senior has the
Yeah,
instruction.
that's all right, but you are there. Well, there is an order of this court
Yes, my lord, lordship may kindly.
to release the petitioner, to release the petitioner, to release the petitioner his provisional pension and other pensionary benefits.
Yes.
Why that has not been done?
Para 12 is.
No, specific instruction on this on Friday, else personal appearance of the concerned officer.
This Friday.
Friday. Could you give me Monday, my lord, or Thursday,
You
tomorrow?
wanted,
Yes,
we will certainly, but keeping the interest of your
my lord, Friday.
client, I'm keeping it on Friday. Heard Mr.
G. Alam.
G. Alam, Learned Counsel appearing for the petitioner, also heard MS
H. Barwa.
H. Barwa, Learned Counsel appearing on behalf of Mr. P. Vinayak, Learned
Counsel for representing the irrigation department.
Learned Standing Counsel
Lordship,
or Additional Advocate General.
additional advocate.
Learned Additional Advocate General, Mr. D. Barwa for
Respondent 3.
Respondent number 3, Government Counsel, Mr. Sorry, MS. So and so, respondent number 9. Mr. So and so, Learned Counsel for the petitioner, by drawing the attention of this court to the order dated 7/8/2025 passed by this court, whereby the respondents were directed to release the provisional pension and other pensionary benefits to the petitioner, submits that the same has not yet been the same has not been released till date. The same has not been released till date. Stop. MS so and so seeks a short accommodation to obtain the that instruction. Relist on Friday so and so. It is needless to be clarified that if the order dated so and so is not complied by the next date of listing, in the event there is no positive, there is no instruction, there is no affidavit. There is no affidavit explaining the reason for non-compliance, adverse consequences as required shall be forthwith passed.
My lord, I just want to point out para 12 of that order, my lord. Lordship may kindly see, it is written, my lord, it is provided directions passed herein above for release of the petitioner for his provisional pension and other pension benefit would be subject to further order that will be passed in the present petition, my lord.
That's all right.
Yes, that is there.
But you are not
I
getting
am not
it
getting, my lord.
only for that purpose.
Yes, my lord. My lord. May I?
Friday.
Friday, my lord. Oblige, my lord.
Yes.
May it please your lordship, my lord, the petitioners were appointed as assistant teachers in the year 95-96. After they were not getting salary on the suggestion that they are excess teacher, then there was some inquiry held, and in the inquiry they were held to be genuine, and my lord, they were regularized. Now the question comes upon that their regularization was after the year 2005, whether they are entitled to the old pension rules or the new pension rules. There were different coordinate benches, different judgments were there. Then ultimately it rested before a division bench, that is at page 125. Your lordship will find. My lord, I pray before that because I have not come before the court earlier, so I may be just governed by this judgment, my lord.
124.
125, my lord. It starts from the second paragraph. Division into diploma. It will same.
Lordship, I'm appealing for the department, my lord. You know, the education department, my lord, has not filed their affidavit till now in the 2025 case. My lord, some time may be given, my lord. We have already taken
The
the.
thing is this, my lord, the state government, your lordship is just looking.
Mr. Fukand, the only prayer that is now being made is whether the issue is covered by this judgment at page 122.
The government has taken a decision that they have stated.
You see that?
In page 126, your lordship will find.
Is it 126? In my brief, it is 122.
Last page, my lord.
The judgment dated 26/7/24.
26/7, my lord. 26/7/24.
Yes, it is 122.
My lord, my W.
Anyway, Mr. Raj,
4651. I mean 4651.
this is 769.
My lord, two cases.
Anyway, we are on this.
My lord, if your lordship allows me, because my lord, I need to get my instructions, my lord. So if
Why is Mr. Chalyap prompting you?
No, he has filed his affidavit, my lord. Since
Finance has cleared it.
They have, my lord, I am.
One second, Mr. Fukan, just read this order. You have it or not?
Yes, I have it.
Read from this writ appeals.
It is page 126, my lord.
Yes, read.
It is informed that in a meeting took place between the Honorable CM of SAM with so-and-so, held on so-and-so, it is decided that the government.
Where are you reading?
My lord, page 126.
No, he can't.
First, from the.
I can't read of any case.
My lord, I have it.
4651.
No.
Yes. 465.
120.
6, the last page.
Yes. It is informed.
It is informed that in a meeting took place between the Honorable CM Assam with the so-and-so, held on so-and-so. It is decided that the government of Assam will consider extending the benefit of old pension scheme to those employees who join the government services after January 25. January 2005, but the recruitment process of the concerned post was started prior to the January 2005, in line with the OM issued by the central government. Learned counsel for the appellants has submitted that all appellants were appointed in the year 2001, and therefore their case comes within the ambit of the opposite decision of the meeting. It is further submitted that the issue regarding the extending the benefit of old pension scheme to those employees who joined the government services after 2005, wherein the recruitment process was started prior to 2005, is pending in the administrative department. In view of the above development, we are of the view that once the state government has decided to consider the demand of the employees who were though appointed after 2005, wherein the recruitment process of the concerned posts was started prior to January 2005, despite the order passed by the learned single judge, it would be appropriate to dispose of these appeals, awaiting the decision of the state government on the issue. It is made clear that if the appellants fail to get any favorable decision from the state government, they are free to approach this court
again by filing fresh writ. Can you object for this order? Mr. Roy Chaudhary, when how many petitioners?
My lord,
When did they submit their?
my lord, their
when they were
appointment letter
appointed?
is page 18. yeah.
When?
It is 1995, my lord.
1995, all
95, my lord, all, virtually all 95.
95.
95.
Both the writ petitions.
My lord, all the.
And the recruitment process was started?
My lord, the 95 they were appointed, thereafter they were regularized.
No, this second part of this order, that to those employees who joined the government service is after 2005, wherein the recruitment process was started prior to 2005. That is also applicable in your case.
My lord, 95 and they were regularized in page 28.
I am not deciding anything, Mr.
the state
Chalia.
government-
Lordship, that decision has yet to be taken.
Correct. So in similar,
Receipts can be forwarded for consideration.
absolutely.
My lord, that
Mr.
much.
Fugan?
My lord.
Heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the petitioners, na?
Petition.
Petitioners. There are only 3 petitioners.
My lord.
Petitioners also heard Mr. A. Fukan, learned standing counsel.
Standing Council, Elementary Education.
Standing counsel elementary education. A. Chalia, standing counsel finance. The grievance canvassed in this writ petitions, in this writ petition, duta writ petition ekelege lulu ba. In the 2 writ petitions is the refusal of the state government to grant pension to the petitioners as per the Assam Services within bracket pension rules 1969 old pension. Correct?
My lord.
You all are OBC teachers.
My lord. No, my lord, I am an assistant teacher.
Okay. Mr. So-and-so, learned counsel submits that the similar issue has been disposed of by the division bench of this court by judgment and order dated 26/7/2024 in where is the starting page?
My lord, page, it will be 51, I think, my lord. It is 54. Read
In
appeal number
WA
180.
188 of 2023. Stop. The operating portion of the aforesaid judgment reads as under A to A, page 126. Having heard the learned counsel for the petitioner as well as the respondents, and having perused the aforesaid judgment in order of the division bench of this court, I am of the considered view that in the interest of justice, this petition, these writ petitions can also be disposed of in similar lines. Accordingly, in as much as the petitioners in the present case were also appointed in the year, were appointed in the year 1995, and therefore their case comes within the ambit of the decision of the state government held on 15/3/2024 Accordingly, it is provided that So what would be the operating decision? That once the decision comes in view of that decision to dispose of the application?
They're similarly situated, Lordship. That has to also be verified, Lordship.
No, that is what?
Yes.
It is provided that in the event, it is provided that that once the state government has decided to consider the demand of the employees who were though appointed after 2005, wherein the recruitment process of the concerned post were started prior to January 2005, comma, in the event the petitioners also in the event the petition the cases of the petitioner is also covered by such decision, correct, by such decision, comma, then the result of the said decision should also apply to them. I think that is what let representations by the petitioners be also filed before the
Secretary, Education Department.
respondent number.
Respondent number 1.
Respondent number 1. Because the decision has not been done till now. So once the decision is done, then only whatever the decision is taken, whatever follows, it will apply to the petitioners if they are covered. Correct? Have I understood it correctly or not?
And also, you may add subject to verification.
So I've already said if covered. What more verification?
That word may be given, my lord, subject to verification.
It is needless to be clarified that the case that episode side number disposed. All right, I will take care of that. I'll edit it.
My lord. Deeply appreciated.
Because I'll just see how I have given the direction.
My lord.
If it is not clear, I'll add it.
My lord. Deeply appreciated.
No problem.
Both the cases.
My lord.
Other one is singularity, individual. Other one is just individual.
Only one. So other one to eta petitioner he to uport likhi dibo lego. 95. And the category is
Assistant.
Excess teacher.
No. After excess teacher, inquiry was done. It was.
All right, I'm not going into that. You verify.
Yes.
Yes, yes.
65.
The lordship here, my lord, instruction was sought, my lord.
Yes.
Regarding recommendation.
Regarding?
Recommendation of the DLC in favor of.
Yes,
the
what
petitioner.
happened?
Recommended, yeah.
So it can be closed.
Yeah.
Recommended. It will have to be placed before the SLC.
Already placed, your lordship.
Huh?
Already placed.
Already placed. SLC also recommended.
Yes, it is there through Secretary School Education, your lordship.
Recommended for compassionate. Heard MS K. Fukan. Sorry, so-and-so learned counsel appearing for the petitioner also heard MS K. Fukan, learned government counsel. Stop. By way of this instant petition under Article 226 of the Constitution of India, comma, the petitioner is seeking compassionate appointment. Seeking appointment on the seeking a compassionate appointment. Huh? Stop. It appears that during the pendency of the instant compassionate appointment on the ground that the father of the petitioner died in harness on 7/12/14 while working as founder teacher of Basad ME School, Karimganj. Full stop. It is submitted by MSK Fukan, Learned Government Counsel, that during the pendency of the writ proceeding, the case of the petitioner has already been recommended by the DLC, and the same has also been placed before the SLC. Correct?
Full education.
And SLC also approved.
Yes, not approved, Your Lord.
Or it is just placed. Has recommended and has
In the last paragraph, it is written.
and has placed the same before the before the concerned administrative department to place the recommendation, to place the minutes of the DLC before the next SLC. Stop. Yes, by when the SLC is going to sit?
That one, I don't have any idea.
Relevant portion of the letter dated 16/9/2025 reads as under quote unquote কৰি দিবা আৰু এইখিনি records লৈ ল'বা marked as X. In view of the fact that the case of the petitioner has already been recommended by the DLC and the same is now going to be placed before the SLC, this court deems appropriate to, and you have also, I think that office memorandum is also under challenge, right?
Yes.
কালি এটা কৰিছিলো নহয়.
They show you yesterday also.
Yes, where is that? You have that order?
The order, I have the number, Your Lord. 2774 of 25.
কি বুলি লিখিলা লাষ্টত? No, সেইটো নকবা. It further appears, এইখিনিটো quote unquote হৈ গ'ল সব. It further appears that the office memorandum dated 18/9/2024 is also under challenge in the instant writ petition. That being so, the instant writ petition is covered by the judgment rendered by the coordinate bench of this court in the case of Abdul Qadir Bakshi, reported in WPC 342 of 2025. Which reads as under paragraph 9. We paisla nekitu? Paragraph 9, 10. তাৰ পৰা সেইখিনি পিছৰখিনি একেই কৰি থৈ দিলে. Disposed of.
Okay.
But Ms. Counsel, I think it is not yet placed before SLC, so maybe you might have to file an application because there is an advertisement which says which has called for the applications of those petitions which were pending where this challenge was put. So you might have to file it, huh? Because this application was filed when?
This application was filed.
In 25.
Yes, ma'am.
On?
Date.
3/4/25 before or after? Cutoff date is 3/4.
After.
So then that will not come. সেইটো কৰিব নালাগে. তুমি এইটো word কৈ দিয়া.
One time is left.
দুপাৰ্ট নালাগে তেতিয়াহ'লে. That simply লিখি দিবা that in view of the fact that the DLC has already recommended in the interest of this court deems, in the interest of justice, deems appropriate to dispose of this writ petition by directing that the case of the petitioner shall be placed before the next available SLC and as and when the SLC meeting is convened, the case of the petitioner shall be considered in accordance with law. It is needless to be ordered accordingly. It is needless to be clarified that the entire exercise should be carried out within a period of 3 months from today. এইটো কথাটো ক'ব নালাগে কাৰণ এইটো ডেটটো মিল নাখাব
66.
May I please, Your Lordship?
Yes.
The matter is regarding non-payment of fire risk allowance to the petitioner since 2024.
non-payment of
Fire risk allowance.
fire risk allowance. Yes.
Lordship.
Your Lordship, I have sent the affidavit for vetting today morning. I have received. No, I'll file affidavit.
As prayed for by MSK Fukan, no, as prayed no, MS, your P. Gohai.
Big Lords.
Heard Mr. P. Gohai, learned counsel for the petitioner, and also heard MSK Fukan, learned CGC. Stop. MS so-and-so submits that the affidavit in opposition after being vetted has been received by her office today morning, and accordingly the same shall be filed within a period of 1 week. It has come within a period of 2 days from today. Released after a week on a date to be fixed by the registry. এইফালে আৰু বাকি আছে কিমান আছে Ms. Chaudhary, your matter is going to take time. The orders are still not over.
Lordship, I'm willing to wait subject to.
You just wait for a while.
Subject that my learned friend waits and does not go.
Mr. Kayal, just give me some time. Let me just finish the orders.
Yes, sure.
Because it makes no sense of keeping all these
everyone-
the learned council waiting.
Yes, sure.
Because I think your matter is going to take some time.
Yes, sure.
Okay.
Keep your blood.
Yes, Mr. Sharma, what is this?
Non-payment of salary, my lord, only 2 months salary, my lord.
Why the salary is not given, Mr. Gogoi?
My lord, I have to take instructions regarding this matter.
Yes, you take it, but I think
Understand, madam.
Mr. Sharma, this has come today first time after the notice.
Yes.
So let him obtain his instruction. Heard Mr. J. Sharma, learned counsel for the petitioner. Also heard Mr. D. Gogoi, learned standing counsel.
Yes, sir.
PHE?
Yes,
PHE. Stop. Mr. So-and-so seeks how much? 1 week.
1 week.
1 week time to obtain instruction as why the salaries
Salary, madam.
have not been released to the petitioner as claimed for. Okay, only on that. Released on a date after a week. Just get that because it's a salary matter. Puja is coming.
He has superannuated matters.
What? So
Obviously.
what? He needs his salary.
No
Expect
pending,
salary.
My lord.
69.
Yes, Mr. Chaudhary.
May I please, Your Lordship? Or the petitioner is aggrieved by the non-payment of her, my lord, family pension.
Family pension.
She being the unmarried daughter of the deceased employee. my lord.
But we have not received instruction from the department. Sometime may be given.
First time after notice.
Yes, ma'am.
All right.
Rest of the. KS Odil,
How much time?
2 weeks.
But that's your last opportunity. Family pension. Heard Mr. G. Chaudhary, learned counsel appearing for the petitioner. Also heard Mr.
KS Odil.
K.S. Odial, learned counsel appearing for
Respondent number 3.
the respondent number 3 and MS. Yes, Miss MS. Students, learned counsel on behalf of respondent number 2 and Mr. C.K. Akbar, learned government counsel for respondent number 1. MS, Mr. All of you are going to file? So good
Basically,
evening,
it will
Nam
come
Jyoti
from
ba.
the respondent number 2 only, madam.
Who's 2? You.
Who is the accountant general?
Who's accountant general?
We forwarded the communication to the deputy.
So that is why let them all file. As prayed for by the learned counsels appearing for the respondents, relist after 2 weeks on a date to be fixed by the registry to enable the respondents to file their respective return in the matter.
Can I pray for a date, madam?
Welcome, Mr. Chaudhary. You have not got.
I'll give you. my-
Yes, ask your junior to
Yes, yes.
take care of that.
Yes, my lord, that is hardly, he should have told me now. we were
I
speaking
know,
together.
that's why I'm
No,
smiling.
no, hardly a matter to be told.
I don't know why nowadays these kind of things are being told before the court.
Correct.
We never used to do that.
We know used to do that.
Yes.
For orders, item number 36.
Yes, why is this for orders?
36, yes, madam.
Contempt.
Contempt matter, madam.
Contempt.
Notice
Here,
was issued.
perhaps, my lord,
Siddhartha?
the new incumbents have to be implemented.
No, we have implemented, madam. I have a number 2065. It is second page.
So what
Second
happened?
page.
Notice has been given?
Issued, yes.
Issued.
Yes, madam. I have taken steps also, madam.
But since petitioner has not submitted amended cost title,
Yes, but it is wrongly.
amended cost title given.
No, my lord, there is no order like that. I have
Huh?
not seen. Yes, my lord. Lordship,
No,
can
but-
you pay-
Particularly দিব লাগে।
দিব লাগে?
Miss,
Okay.
if someone has been impleted, then you'll have to give an amended cost title.
Yes,
So
ma'am.
you
That
ask
I
your
will-
junior to check.
Yes, yes,
As prayed for by MSK Devi,
Certification.
learned counsel appearing for the petitioner, relist after
Okay.
3 weeks on a date to be fixed by
Yes,
the
yes.
registry to enable the petitioner to take appropriate steps to submit the amended cost
Amended,
title
yes, yes.
before the registry for doing the needful.
Yes. After taking.
Yes, yes. 3 weeks.
37.
Amended cost title?
We have given, my lords, implemented, my lords, the incumbent therein is now retired. They have preferred a writ appeal, but there is a issue of delay out there, my lord.
No, but who is appearing for the new implemented respondents?
They should say,
Who is appearing?
they had appeared for.
Notice issued or not?
Notice was issued, my lord. They have responded also.
Yes.
Govind
Govind Mohan.
New Govind Mohan is there.
Who is appearing? Heard Mr. D. Gogoi, learned counsel for the petitioner, also heard MS. B. Rabha, learned counsel appearing for,
All the respondents.
so newly also.
Yes.
There's an order of 21/5/25. Miss A. Gayon has taken as
Correct.
she had appeared for respondent number 3 and 4. Notices of waive.
Yes, I'm asking you, you're saying for all. Please have these, you are appealing for 3 and 4. So what about your affidavit?
Maybe done so that we can file our affidavit.
So, heard cert qua, MS so and so seeks 2 weeks time to file counter affidavit. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry.
All right.
38, 39.
But in 30th, 39, Lordship will kindly come to order dated 25/6/25, my lords.
Order dated?
25/6/25.
Yes.
My lord, in this case, there was a direction to held a test, medical
As
test.
to why the said medical condition suffered by the petitioner herein was not detected in the first examination. Yes, Mr. Parashar?
Malad, the thing is that Malad, to understand that Malad may come to page 20 of the contemplation. What is the order of the court, Malad? BB Ram in the BB Rambe contemplation.
Affidavits have been filed on.
File. For the other earlier Malad, incumbent we have filed Malad.
Page?
Page 20 Malad, part of the order, para 14. Para 14.
Do affidavit refer to larger feet as
Paragraph 14, Malad.
Page.
20.
Yes.
It is for the director if the petition is found to be fit in the appeal review medical court.
Page 20 is not the order of this court. Why all the page marks are different?
Page 20.
29, 16.
16. আপোনাক মোক দিয়া copy এইটো. Malad maybe in 16. It's a part para 14 of the order.
Yes, 16.
Paragraph 14, my lord.
Paragraph?
14.
Page 16, there is no para 14. You please verify the pages, another date. Relist on another date.
Madam,
Give a
they got
date.
some urgency.
Please have a look at the pages next
Alright.
week and then any date.
Madam, yes.
Check the court's copy.
My lord.
It's unnecessary wastage of judicial time.
Item 14.
Definitely, your lordship.
Yes.
This is a contempt matter, lordship, for non-compliance of order of this honorable court.
Affidavits.
So last occasion, we have placed the order which was complied with, and she was supposed to obtain instruction if from the client.
Direction was to pay the minimum pay scale, lordship. And they are in this order, they are saying that they cannot pay. So that is not the compliance.
Where is the order of the court?
Lordship, lordship, the
24.
23, from 23, lordship.
You are Mr. Deka, na?
Yes, Lord.
Mr. Deka, you, our client, have not filed any affidavit, right?
No, no,
In a
no.
contempt proceeding?
Lordship, on the
They
last.
have not filed, correct? Very well. Now, we are going ahead.
Lordship.
If we find that there is no compliance, be ready to face the consequences.
Lordship.
Because your affidavit has not come. So therefore, there is no unconditional apology whatsoever before this court.
Lordship.
The contempt proceedings are not writ proceedings.
Lordship will allow us to file.
The contempt, no, you want that prayer, you can ask that prayer.
Lordship.
But don't come and say that there we have complied, give a order before this court, and then when the other side is saying it is not complied. After that, if this court starts investing time and this court finds that there is no compliance, then you must be ready to face the consequence. Do not say then that you need time. You want time, you ask now.
Yes, Lordship.
Because these are not
the
writ
affidavit.
proceedings.
We'll
Don't
file the
take the contempt proceedings so casually.
Absolutely, Lordship. We'll file the affidavit with.
As prayed for by Mr. So-and-so, released after 2 weeks to enable the contemner so-and-so to file affidavit in the matter.
Obliged, Lordship.
Impleadment.
41.
Wait, petition, lordship. Lordship, it is also contempt application. Now,
Yes,
I
Mr.
like-
Kaushik.
I pray for time to file affidavit.
All right. As prayed for by Mr. B. Kaushik, clerk counsel appearing on behalf of the sole respondent stroke contemner, released after
2 weeks, my lord.
2 weeks on a date to be fixed by the registry to enable the sole respondent contemner to file return in the matter.
42.
I'm did.
Yes.
Allow me time, 2 weeks time to file my affidavit, madam.
Same kori diba, khali naam to change kori diba. Sole contemner,
No. There are.
you are for?
I am for.
Just give your respondent number.
1.
Respondent number 1 kori diba khali, huh? S. Bora.
And Lord,
Here also I have received the instruction. I like to file my affidavit.
Sole contemner.
Sold.
3, 2 weeks, 2 weeks kori diba.
Great to me.
44 and 45.
Meet your lordship. This is before my NS senior start, my lord. I am led by additional AG P. Nayak. He's in late month.
This is for orders.
Orders, one of the repetition, my lord.
Item number?
44 and 45. Question, kindly take up the repetition first.
All right. Since Mr. P. Nayak is not available, another date. When, Mr. Saikya?
Friday, ma'am.
Friday will be difficult.
Monday for admission, ma'am.
Monday.
For admission, ma'am.
It will come
My lord, repetition.
Monday. Yes.
Lordship.
Obliged, ma'am.
As prayed for on behalf of P. Nayak. huh?
Maybe lordship. Kindly adjourn for the time being, lordship. Kindly adjourn the matter for the time being, lordship.
No time being. This is item number 46.
46, lordship.
You are Mr.
S. Islam, lordship.
As prayed for by Mr. SS?
S. Islam.
S. Islam.
Yes,
Learned counsel appearing for the petitioner, relist after
1 week, lordship.
after 1 week on a date to be fixed by the registry.
Deploy.
7.
Yes, Mr. Datta? Yes.
Earlier I was appearing on behalf of the Corporation Bank. Now the Corporation Bank has since been merged with Union Bank of India since 2020. So therefore, my lord, I don't have any instruction.
You obtain your instructions by the next date.
No, Union Bank, my lord, we are not empaneled with them, so therefore, my lord.
No, but they must be informed about the pendency of the case. Otherwise, we'll have to issue a fresh notice.
Yes,
Since you were already, but Mr. Datta, since you were already, but you may not know them.
We don't know them, my lord. Union Bank of India, we don't have any relation with. And the petition is also, my lord, they will have to change because they will have to.
Then I think you take your obtain instructions. Perhaps you will have to implead this.
Yes, yes.
After the
Yes,
merger.
What had happened in this case, my lord,
There has been a merger.
Merger.
So if there is a merger, a new entity has come in.
yes, my lord, I have to take it actually.
You
this-
take it.
This matter, my lord, what had happened earlier
So
dismissed.
that's all right, whatever has happened, but before we proceed further, the new entity must be brought on record. Otherwise, there is no respondent as on date.
Very right.
Heard Mr. R. Islam, Learned Counsel appearing for the
For the legal aid
applicant.
council, legal aid council.
Legal Aid Counsel for the applicant, na?
Yes, ma'am.
And Mr. S. Datta, Learned Senior Counsel, assisted by Mr. S.
Yes.
S only, no? S. Datta, Learned Counsel for the petitioners. Stop. It is Mr. R. Islam, so and so, in view of the merger that has taken place, shall obtain shall do the needful pray 2 weeks time to do the needful in terms of the merger that has taken place in the meantime.
I will withdraw this.
3 weeks.
Yes.
3
My
weeks.
lord, I will withdraw this petition, will file a fresh one.
Whatever you do.
Yes, sir.
Oh, you're withdrawing?
Yes, yes.
Okay, so then you say a Uparakhanda and he, Mr. So-and-so, submits that in view of the merger that has taken place, he has instruction to withdraw the instant application and file afresh.
Yes.
MAC stands dismissed on withdrawn with liberty to file afresh.
Much obliged.
Both the IAs or one IA?
Both the eyes.
Both the IAs. Both the
One
IAs.
for 48.
Thank you.
May I please, Your Lordship?
Yes.
Lordship, may I kindly see order dated 11/8/2025.
Yes.
Service upon the respondents has already been completed and on that.
Nobody is appearing, Mr. Bora.
Yes, none has appeared.
We'll wait for another date.
Lordship, may I kindly see page number 13 for a moment.
It's okay. We'll wait for another
For the
date.
last 11 years, they are.
Heard
paying-
Mr. R. Bora, Learned Counsel appearing for the petitioner. It appears that despite notice having been effected, there is no representation on call on behalf of the respondents stroke contemners. It further appears that on the last occasion, I 11/8/2025 as well, there was no representation on behalf of the respondent. There was no representation. Stop. However,
For the last 11 years, Lordship, they are not paying the.
no, who is one? Because no AD card or unserved notice has been received back on R1.
Yes, R1 is the executive engineer, PWD, Lordship. Umrangso division.
No, but then you'll have to take fresh steps, no?
No, because the process server report says that it was sub. That reflects in.
No, but
Your
the
Lordship,
office
Lordship.
note.
Yes, there is another office note. Your Lordship will find it.
How many total respondents, Mr. Bora?
As per the direction, only three respondents were directed to complete the.
No, I am not. Mr. Bora,
Lordship.
please answer the query put by the court. How many contemners have you made parties here?
Three contempt.
3 contemners. Now, notices have been completed or
respect
not?
of-
Where are those orders, office notes?
Lordship,
Because the last office note says process server's report has been received back in respect of R1 where it is mentioned that notice has been served. However, no AD card or unserved notice has been received back for R1 in connection with notice issued by registered post with AD.
yes.
What about 2 and 3?
2 and 3, because Your Lordship may kindly see page order dated 7/2/2025. Because this honorable court has only issued notice in respect of respondent number 1 only. Because respondent number 1 is the authority who will complete the exercise. And therefore, notice was issued only to respondent number 1. Actually, it's a matter of family pension.
It has to be, you take fresh steps. It's a contempt proceeding. heard Mr. S. Bora learned so and so. Office note dated 19/6/2025 indicates that though process server's report has been reflects that notice has been served in respect of respondent number 1. However, no AD card or unserved notice has been received back for respondent number 1 in connection with notice issued by registered post with AD. It appears that thereafter, when the matter was listed on 11/8/2025, there was no representation on behalf of the contender stroke respondent number 1. It further appears that today as well, there is no representation on behalf of the said contender stroke respondent number 1. Mr. R. Bora shall take fresh steps in respect of the respondents stroke contemners by registered post AD within a period of 2 days from today. Relist after 3 weeks on a date to be fixed by the registry. Mr. Counsel, you have made them parties. You please take, because later on we can't delay this matter. Yes. All right, 1 Korea. Fresh steps 1.
Again, the same report will come.
Let it come. Yes.
49 to 52.
In this matter, in item number 49, we have filed an IA to which the BTC have filed their affidavit in opposition today. And we have received.
You want rejoinder?
Yes.
As prayed for by Mr.
A. Talukdar.
A. Talukdar, learned counsel appearing for the petitioner, relist after 3 weeks to enable the petitioner file rejoinder against the affidavit in opposition filed by respondent number 3. Respondent number 3.
Okay, by next week only we can do so.
2 weeks. Yes, next.
53. In 52, I am appearing, there is this interim order not to fill up one post.
52.
52 in the same
Same thing.
All right, so that to continue.
Yeah, that has to be continued. They has to produce the records. They have filed affidavit in opposition, but without any enforcement.
What will fix it after vacation, my lord? In the meantime,
They will produce records and the matter may be finally disposed of.
No, this is part of
that series, my lord.
the one which I just.
Yes, 49 to 50.
So
But here
interim, if any, to continue till the next date of listing and let the records pertaining to the issues involved in the writ petitions be also be made available before this court on the next date of listing. Yes.
Date may be given so that.
It'll come, Mr. Das. Yes, next.
53. 53.
That's why notice answer to respondent number 7, my lord.
Awaiting.
Yes, my lord.
Await service in respect of
Respondent number 7, my lord.
respondent number 7.
Take a fresh.
You want to take fresh?
Yes, my lord.
Then say that as prayed for by Mr.
A. Hussain.
A. Hussain, learned counsel appearing for the petitioner, relist after 2 weeks to on a date to be fixed by the registry to enable the petitioner to take fresh steps in respect of respondent number
7, my lord.
7 within
2 days.
2 days from today.
Obviously, my lord.
455.
My lord, in respect of the IA, my lord, I was asked to obtain instruction. I have sought for the instruction, but I have not received it, my lord.
My lord, what I pray, my lord, this matter is important in a sense, my lord. From May 24, these persons are not getting any salaries.
Yes.
They are serving it. There was an order from the court that you consider regularization. That was, my lord, rejected by them. Then thereafter the court, your lordship will kindly see page 43.
Page
43.
40.
43, my lord.
43. Yes.
Relevant is at page 47. One last paragraph, considering the fact that a coordinate bench by an order dated so and so pass already directed to release salary and consideration of the case of the petitioner for extension.
Yes.
So therefore, my lord, the court directed, my lord, this order will be stayed and all consequential orders will also.
What do you want today, Mr. Das?
Today, my lord, it is important that they should file an appeal because we have not been.
So you file it by the next week?
Yes, my lord.
You have already asked for instructions. It's
Yes,
not
my lord.
coming.
I
You
have
give
got
them a call. Otherwise, by next week, if still it's awaiting, we shall have the officer in court.
No, my lord, actually the problem is that the officer concerned dealing with the matter her mother and mother-in-law both are not
I see.
well, my lord, and that's why she is on leave, my lord.
All right.
And they have communicated me that they need some time. my
How
lord.
much time? This is the
Weeks.
last chance.
2 weeks,
So
my
after
lord.
vacation, I'm placing it.
Yes,
By
sir.
then it should come.
Yes, my lord.
Heard Mr. Bidas, Das, learned senior counsel, assisted by Mr. D. Kalita, learned counsel for the. I'm passing it in the IA.
Yes, my lord, the similar,
Applicants.
my prayer will be, my lord, similar, in matter, my lord, this court has disposed of the.
All right,
case.
let him has his instructions,
Yes,
Mr. Das. As prayed for by Mr. Bora, no, so as prayed for by Mr. Bora, learned counsel, learned standing counsel, no?
Yes,
Standing
sir.
Council, Health and Family Welfare Department submits that though that instructions are still awaiting.
Yeah.
Relist at a date dated after vacation on such and such date to enable the respondent to file return positively by the next date of listing.
That will be hard on the table.
Yes, next.
Well, both the cases interim judge.
Interim, if any, shall continue till the next date of list.
Yes, ma'am.
6. Very clear. Services completed in respect of respondent number 4
Yes.
and matters related to non-payment of.
What about the others? All respondents completed.
Yes, yes, yes. So,
You are appearing for?
Lordship, I'm appearing for respondent number 1 and 3.
What about the other respondents?
Lordship.
Director of technical information secretary.
Yes, you are appearing for someone?
Education Department of Finance is here.
So where are they? Yes, who is appearing for whom? I have another matter to take up. They are waiting. Councils are waiting. An urgent matter.
Yeah, the matter related to the non-payment of salary, the last since.
Mr. Council, first let the service be complete.
Yes.
You have come only now. This is after return notice, the first time the matter is listed before this court. You don't want the service to be completed. The court has to be satisfied. Yes. Who are you all appearing for?
I am appearing for the finance department here.
Respondent number?
Respondent number 2.
2. And then?
Lordship, though the service have been completed, respondent number 4 have never appeared.
Not appeared. You are for 2, right? And you are for? 1 and 3. 4, nobody has there. Okay. Heard Mr. So and so learned counsel for the petitioner. Also heard MS. I thus learned counsel appearing on behalf of
Mr. D. Upamanyu.
Mr. D. Upamanyu, learned counsel appearing for respondent numbers 1 and 3. And Mr. A. Chalya, learned standing counsel for finance for respondent number 2. It appears that though service in respect of respondent number 4 has been completed in terms as reported by office note dated 10/9/2025, there is no representation on behalf of respondent number 4 on call. Be that as it may, service in respect of respondent number 4 having been completed, the matter shall proceed. Yes, you all want to file something? By when?
After vacation, get the instruction.
The respondent seeks 2 weeks time to file return in the matter. Prayer is allowed. Relist after 2 weeks to enable the respondent put their respective returns in the matter. It is needless to be clarified that since the urgency has been canvassed on behalf of the petitioners, the return shall be positively filed by the next date of listing.
May fix a date.
Yes, next.
57.
May it please your lordship.
Yes.
Lordship, where is the office note that is 15/9, lordship?
Service.
As regards completed, lordship.
All completed?
All completed, lordship. If they come up for admission.
Yes.
I'm appearing for 1 to 5. I'll file my affidavit within 2 weeks.
Heard Mr. M. Nath?
DJ Kapil.
DJ so and so, learned counsel appearing DL Deka.
DJ Kapil, lordship.
DJ Kapil, learned counsel appearing for the petitioner. Also heard Mr. SC Kaya, learned standing counsel for the Assam University stroke respondent numbers 1 to 5. Mr. Kayal seeks how much time?
2 weeks.
2 weeks time to file return in the matter. relist after 2 weeks on a date to be fixed by the registry to enable the respondent put their return by the next date of listing. Yes,
Interim order pass.
interim if any shall continue till the next date of listing.
Supplemented is item number 70.
A hearing matter in that.
Lordship, this is an IA filed by the Finance Department, Lordship.
Yes, for
We are seeking an extension, Lordship. Time frame was,
who is appearing for the other side?
Lordship, here, the main, this is the IA is coming for the first time, Lordship. The main respondent, we have to take steps. Lordship.
So steps,
Lordship.
to notice, 2 weeks. And you are appearing, someone is appearing for the other respondent.
Government, yes, Lordship.
So notice registered so and so accept corridor.
Yes, Lordship.
Who is accepting for whom?
2 and 3, Lordship. One is Social Welfare Department and Accountant General. Lordship. They don't have much of a role, Lordship.
No, but you're accepting notice or not accepting notice? I'm only asking who you're accepting notice. You're accepting for? Social welfare. That is number 2, Mr. C.K.S. Bora. And MS?
Accountant General.
For 3. Extra copies and for 1 registered post AD within 2 days from today. 2 weeks returnable.
Ending item 67.
Hearing. It is cause list to sir. What about that item 58 and 59? Are the councils here? I don't think there'll be time for your matter because this matter was specifically kept for today. And both the councils have been waiting since 10:30. So you suggest a date, consent date, and it will be given to 58 and 59, Okay. Yes, Ms. Chaudhary.
Lordship, the petitioner before Lordships is the assistant professor in the DFU campus of the Assam Silchar University. Sometime in the month of October 2024, he was subject to a grievous assault by an unknown person, in which his wife and his father-in-law were a part of that entire assault. And he was grievously injured to such an extent that he had to be hospitalized. He was in the ICU for several days, and then for another 1 month, he was under treatment. During such time, while he was having these problems, some of his colleagues in the department have tried to catch hold of 2 other girls under his. Now, this is the entire case is because of the fact that the petitioner used to be a guide for several girl students. Now, taking a kind of a revenge against him, a false complaint has been lodged against him. I'm not taking your lordships on the facts of those complaints. The complaint was on the basis of a sexual harassment complaint. I will, because of the fact that this is not a disciplinary proceeding matter, the matter relates to the suspension of the petitioner. I'm not going to take your lordships to the entire facts of that particular case.
Here the suspension, this is the 3rd time or something, no?
So the suspension order was issued in December 2024, and this is the 2nd extension. Second extension.
According to you, reasons are not.
Reasons were neither given in the 1st extension, nor have they been given in the 2nd extension.
Charge sheet is not yet filed.
Charge sheet has been given to me. I have duly appeared.
That is within that 90 days.
It is, yes. So we are not concerned with the case.
Now, your only thing is that after issuance of the charge sheet within the 90 days, after the expiry of the 90-day suspension period, though they have extended your suspension for another
180 days first in the month of March, and then now another.
However, no specific, no reasons.
No cogent reasons have been recorded.
So therefore, Ajay Chaudhary back.
Therefore, Ajay Chaudhary. My entire case is based on Ajay Chaudhary. I am not going to. I seek your lordship's liberty.
Then I think let us see those 2 suspension orders.
Yes, very concise, your lordship.
Yes.
I'm just going to confine my submissions to that. Your lordship will kindly take up page 41 for a moment. That is the first initial order of suspension.
Yes.
Whereas a disciplinary proceeding against Dr. So-and-so of Assam University DFU campus is pending. Now, this is the order itself is incorrect. There was never any disciplinary proceeding pending against me at that point of time.
not anything at all. But they have said it is pending. And whereas a letter has been received from the District Commissioner Kabi Anglong, Assam, so and so, dated 17/12/2024, and from the Complaint Cell National Commission for Women, wide email dated 18 December 2024 on alleged sexual harassment at the workplace. Now, therefore, the competent authority in exercise of powers conferred upon him by Rule 10(1) of the CCS, so and so, hereby places the said Shri Dr. So and so of the Department of Hindi, Assam University, Difu campus under suspension for a period of 90 days with immediate effect. It is further ordered that during the period that this order shall remain in force, Shri so and so shall not leave the headquarters, etc. This is the first order of suspension. You also will kindly note 18th of December 2024. Now thereafter, after a gap of almost a month and a half, on the next page, you also will find this is the memorandum of charges which has been issued against me. On 12th of February.
After 1 month and a half, no?
Yes, Your Lordships. On 12th of February, almost 2 months, Your Lordships may say, because it is 12th of February. So almost just 6 days before the completion of 2 months. This document was dated 12th of February. It was received by me by way of an email only on 21/2/2020. 21/2/2025. This was the charge sheet which was framed against me, Your Lordships. Subsequently thereto, I have been
And the time limit here is 90 days.
90 days.
So
in
3
the
months.
ICC. That is the concern, Your Lordships. I am not sure whether they are doing the ICC, whether they are doing a Rule 14 proceeding. Nothing has been communicated to me.
Is the time limit different?
Lordships, it might be different because ICC is definitely 90 days. Rule 14, there's no such time period prescribed. But considering the fact that this memorandum of charges has been issued under Rule 14, but initially, you also will find that the suspension was under the ICC. They're saying that in fact, there was no ICC at that point of time, but before this, before 1812, I was made to appear.
This is Rule 10, one of CCS rules.
CCA rules 1965.
So that is 3, I think the time limit is 3 months?
Yes, Lord.
3 months?
Yes, Lord.
Now, in any case, Your Lordship, I have appeared before the inquiry committee. They did not provide me with several documents. I kept on asking for those documents. They have not done it, but I have given them my entire defense. I have given them the electronic evidence to prove my innocence in the matter. And to my knowledge, the inquiry proceeding is complete. This statement was also made by the Learned Counsel, appearing, if Your Lordship will kindly peruse the order of 4/8/2025.
Are that required, all that?
No, not required actually, Your Lordships. I will just take Your Lordships to the second suspension order,
Yes.
page 73.
Yes. Page?
Page 73, Annex to G.
73. Yes.
Whereas a disciplinary proceeding against Dr. So-and-so is pending and order of suspension is in force by order number so-and-so dated 18/12/2024. Now, therefore, subject to ratification of the Executive Council of the University, the competent authority in exercise of the powers vested upon by Rule 10(6) of the CCA rules and as amended from time to time, and the powers conferred upon by the Acts and Statute of the University, hereby extends the period of suspension of Dr. So-and-so for a further period of 180 days in continuation of the earlier suspension order referred to above and with immediate effect from the order of completion of the period of suspension issued by order number mentioned in the first para.
Where are the reasons?
Nothing. No reasons, Your Lordships.
Where are the reasons?
No reasons. And that I have come to you before Your Lordships challenging this particular order. Now, during the pendency of the writ petition, the disciplinary inquiry is complete. Now, if the inquiry is already complete, then all the more reason to not keep me under suspension.
It's complete.
It is
It's an admitted
statement made by them, Your Lordships, not by me, because I have not been called back before the authorities. So I do not know whether it is complete or not. They have a tendency of not informing me.
But Mr. Kayal, Ms. Chaudhary, I shall come back to you.
Yes.
Mr. Kayal, a plain perusal of this order, 10th March 25. Where are the reasons?
We file a affidavit and we have explained.
Affidavit is different.
No,
Where are the reasons here?
Review committee passed an order and intimated the Vice Chancellor thereafter this order was passed.
Where are the reasons?
Lordship, I place my affidavit.
Is there an annexure?
Yes, Lordship.
Where is your
My
affidavit?
learned friend is referring to annexure 13, page 154.
Anyway, then I think you complete yours first.
Now, while this entire proceeding was going on, you also kindly just have a look at the order passed by this honorable court on 14/8/2025.
14.
14/8/2025. Heard so.
While the additional affidavit is.
I have filed it.
यार মাজত কে ভৰাই দিছে কিন্তু ইয়াৰ মাজত কে ভৰাই দিছে অৰ্ডাৰছৰ মাজত সিফালে যাব লাগে নহয় জানো 14/8 yes
25. I'm reading second paragraph, Your Lordships. So and so submits that the inquiry proceedings against the petitioner have been completed. So it is a statement made by them. The inquiring authority is in the process of furnishing the inquiry report before the disciplinary authority, and thereafter the disciplinary authority is likely to take appropriate decision and pass orders in the matter. He therefore submits that the matter be posted after 2 weeks. The learned counsel for the petitioner does not object to the prayer made so and so on 2/9. Your Lordship will then find again on 2/9 same prayer, no this thing. So from 14/8, we are today on 17/9, no action has been taken till date. In the meanwhile, they issue another order, which I have placed it before Your Lordship by way of the additional affidavit. Page 174, Your Lordships. Now they have once again extended my suspension for another 90 days. Same verbatim order, absolutely verbatim order, no reasons assigned.
this is after that submission
After
made
submission made by them, they have now again placed me under suspension, so second paragraph, for a period of 90 days. So the first one was for 180 days, now it is 90 days.
yes
And Your Lordships will kindly take up the affidavit in opposition filed by the respondents.
yes
I'm taking Your Lordships to only one particular page.
this is 2 3 and 4 affidavit
Yes,
by
yes,
2,
yes,
3,
yes,
4.
2, 3,
Yes.
yes. Page 154, Your Lordships. If my learned friend is relying on this particular document to say that they have reasons assigned, then sadly it is a very, I do not want to make any comments.
Yes.
Page 154, dated 7/3/2025. Now this is just before they have placed me under suspension.
Yes.
To the Honorable so-and-so, report of the 2-member committee on review of suspension in respect of Dr. So-and-so, Department of Hindi. Honorable Sir, on perusal of the order of suspension issued by number so-and-so dated 18/12/2024 and the issue of charge sheet to Dr. So-and-so, Assistant Professor, Assam University, Difu Campus, wide number dated 12/2/2025 and the proceedings thereafter, the committee is of the opinion that the proceedings is still pending. The period of his suspension may further be extended by 180 days under the provisions of Rule 10, 6 and 7 of CCA Rules 1965, and the substance and allowance may remain unchanged. Where are there any reasons recorded by them, Your Lordships?
Yes.
That is my humble and very straightforward case before Your Lordships. There is no reason, and if the inquiry is complete, which is as per their own statement, Your Lordships,
All
then
right, Ms. Chaudhary.
reason for them to revoke my suspension.
Yes.
I'm not bothering Your Lordship with the case laws.
Yes,
If required,
you have a right to reply. Yes, where are the reasons, Mr. Kayal?
Lordship, may please, Lordship, as my learned friend has already submitted with regard to first review. Second review, Lordship, allow me. I want to place the report of
no,
the.
that is not on record, Your Lordships. It is not on record.
Just let me have a look.
I may.
I know it is not on the record, so
I'm just having I'm not yet accepting this document. I'm just curious to see this
This is the
document.
report of the review committee. First page, second page is on the river. Just received on my email today at 11 o'clock.
Ms. Chaudhary, it's a repetition of annexure 13 and nothing else.
Lordship, may please to see.
It's just a repetition.
Yes. Lordship.
Just check. I think it's a verbatim repetition also. You check properly.
This is the report received by me, I placed before Lordship. Whether it contains.
Yes, Mr. Kayal.
No, Lordship.
If
I want to place the rule, relevant rule,
Yes.
which Rule 10, 6 and 7.
Mr. Kayal, you ask your juniors to make photocopies of this for.
I have submitted one copy to extra.
No, my copy I have given it.
No, another copy I have given.
Asa? Duta copy asa?
Yes.
Okay. Apply price to?
I given two pages. First page,
Oh.
it is a email as I received on 12th of this month
10/6
in connection with WPC number so and so the matter related.
No, but this is the reasons, no?
Yes, sir.
This is the reason
This is the report of the review.
that review.
Another email I received from the law officer of the university. It is stated that in connection with WPC number so and so, the matter related to Dr. Aniruddha Kumar. I would like to inform you that the ICC has submitted its report where the prima facie evidence is found and charges is established against Dr. Aniruddha Kumar. The matter is going to be put before the executive committee meeting scheduled to be held on 25th.
That is all right. That is not for extension. We are not concerned with all that.
I'm just submitting.
Yes.
Because my another friend raised that report was not submitted. This is the in proof of that, Lordship, I received an email. Now, Lordship,
That's because these things are not on record also. So Ms. Chaudhary doesn't know all these developments.
No, definitely.
Anyway, but Mr. Kayal, let us be focused on the issue that is
may come to
that calls for a determination from this
Yes.
court in the facts of this case, correct?
Rule.
Whether a reasoned extension has been issued or not. I think that is the issue.
Yes, Lordship.
Correct?
Lordship, please to.
Now, for that issue, one has to first see that Annexure 13.
Yes, Lordship.
Correct? That is your reasons.
Then relevant rules.
And correct?
Yes.
And this. Now, rules. Let me see the rules.
CCS,
Simple.
PCA rules.
Rules.
Copy that.
Mr. Das, you have not given the list of books? Yes.
So I had told him to make a copy of the rules.
Rule 10.
Rule
10
10.
speaks about suspension. I want to rely on rule 6 and 7.
This is what rules, Mr. Kayal? CCS.
Civil service classification.
Deepak Mali is on this rules only, no?
Yes, Lord.
Deepak
is on-
Mali is on this rules.
Yes.
But that is on the basic issue is
Expiry.
90 days.
90 days expiry.
Yes.
We are not concerned with that here, Your Lordship.
Yes.
State Lordship may come to rule 6 and 7.
Rule 6 and 7.
Married law.
No, under 10.
10/6.
10-6. Oh, that's why I was getting a little confused. Yes. Yes, Mr. Kayal?
Rule
Read.
6.
Yes.
An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before expiry of 90 days from the effective date of suspension on the recommendation of the review committee constituted for the purpose and pass order either extending or revoking the suspension. The subsequent review shall be made before the expiry of the extended period of suspension. The extension of suspension shall not be for a period exceeding 180 days at a time.
Yes.
The rule does not say that
Yes. That there has to be reasons. Yes.
Mr. Counsel, please.
Yes.
Then rule 7.
Yes.
An order of suspension made or deemed to have been made under sub-rule 1 and 2 of this rule shall not be valid after a period of 90 days unless it is extended.
Which one? Which one? Rule?
7.
Rule 7. Yes.
An order of suspension made or deemed to have been made under sub-rule 1 and 2 of this rule shall not be valid after a period of 90 days unless it is extended after review for a further period before the expiry of the 90 days.
90 days. So here they are saying that it has to be extended.
Yes,
Provided, can you just read that part also?
it is to be before,
Provided no such review.
no-
That is not, I think we are not concerned.
Yes, sir.
Now, where is Ajay Chaudhary?
Probably it is on the record.
A lot of given the booklet 2015, 7 SEC,
No, I think I should have a copy of Ajay Chaudhary.
page 291.
Yes, sir. Yes, sir. Para 21. 1 second, let Mr. Kayal first finish. He hasn't finished, Mr. Chaudhary. Mr. Kayal, you have Ajay Chaudhary.
Let's see if I just.
Yeah, no, no.
Yes, sir.
Let's just see para 21 once. Yes. We therefore.
We therefore direct that the currency of suspension order should not be extended beyond 3 months. If within this period, the memorandum of charge sheet is not served on the delinquent officer or employee. If the memorandum of charge is served, a region order must be passed for the extension of the suspension. As in case in hand, the government is free to transfer the persons concerned to any department in any of its office within or outside the state, so as to serve any local or personal contact with that he may have and which may misuse or obstructing the investigation against him. The government may also prohibit him from contacting any person or heading record or
That
handling
may
record.
not be so much required, but this part is clearly saying that even if the memorandum of charge sheet is served, a reasoned order must be passed for the extension of the suspension.
Yes, it is provided.
Correct. No, a reasoned order.
Yes, it is, I think, let's say, but in my submission.
But your submission is that because the rule doesn't say a reasoned order,
That is
therefore, but then what about the apex court decision?
No, Lordship, that is there. Now, Lordship, I want to place paragraph 4.7 of my affidavit. Page 104.
Page
Page 104.
104.
Paragraph 4.7.
4.7.
No.
Yes.
Married row.
Yes, please.
That the deponent wished to state that the committee was constituted to examine and review the suspension of the petitioner in light of CCA rules by notification dated so and so. The said committee has submitted its report on 7th March 2025 with an opinion that the period of suspension may further be extended by 180 days under provision of Rule 10(6) and 7 of CCA Rules 1965, and substance allowance may be remained unchanged. Moreover, the university authority in its capacity has inquired about the situation of the DFU campus and came to knowledge that the student and local persons are very aggrieved by the alleged incident of sexual harassment and the university.
Mr. Kayal, this is okay, but you are understanding the question,
Okay,
right?
I got
Because you are also bound by the record.
Yes, yes.
You cannot change
Yeah,
anything,
definitely.
right? So the undisputed position that emerges appears to be that after the suspension, the charge sheet was issued,
Yeah.
and thereafter the suspension was
The
extended.
review order must
The
contain
review order is there. There is an order of extension,
reasons should be there.
but reasons were not there.
Yes.
Now, second time also it was done, third time also is done.
Second.
Second
Review was
time. Second time. And again it is done now. Third
No,
time,
no, initially he was suspended, then it reviewed
correct,
two
sorry. Second extension. So total 2 extensions.
Yes.
And both the extension times, it appears no reasons as such given.
Uh,
Now your stand is that under the relevant rules,
Only review.
you are not required to give reasons.
Yes.
But your rules doesn't say that you are not required to give
No,
reasons.
it
Correct.
depends.
No, the rule is silent.
Yes.
Now, when the rule is silent and there is a decision of the apex court,
That Lordship,
then
that is there, Lordship. I cannot make any
Correct.
comment on that. But Lordship, one thing is there.
anything more?
No, Lordship, one thing is provided in the paragraph 21 that Lordship, if Lordship allows, I want to read.
Yes, please.
As in the case in hand, the government is free to transfer the person concerned to any department in any of its office within or outside the state.
Hmm.
So Lordship, he's remaining in DFU campus.
That is for you
No,
to
Lordship.
take a call.
Lordship, if Lordship provides, then
Huh?
it depends upon the order of your Lordship.
Sorry.
If your Lordship that the extension is required to be set aside, Then Lordship liberty be given to the, sorry.
That too is your prerogative.
No, Lordship, because Lordship, if Lordship director will be instated in place he is working, because we have two campus.
No, wait. Is it not your prerogative to transfer the petitioner?
That's
Is this not a transferable job?
This is transferable, but
Then-
we have two campuses, one in.
So that you take a call. Why the writ court should come into that? You have the power.
No, Lordship.
You have your, huh?
No, suppose Lordship.
I'm sorry, Mr. Kyle, I'm not being able to appreciate this part of the argument from
No,
that
because it is
that is
provided-
coming, because why do you want that liberty from the court?
Because Lordship, because he was suspended from the DPU campus.
He was suspended from the
DPU campus of Assam.
DFU campus.
Yes, sir.
And now you want to send him to where?
Because we have only two campus. Main campus is in Silchar.
Silchar.
Yeah.
So you want a liberty that he can be transferred to Silchar campus.
That's why we have made this statement. What is the situation prevailing in the depot campus due to this reason?
This is why you showed me this paragraph, 4.7.
No.
Huh?
Yes.
Anything more?
This is my humble submission because the rule doesn't provide for.
Okay, noted. Yes, Ms. Chaudhary, anything?
Lordships, I'm not going to bother you, Lordships, with the entire case laws which are there. So, pursuant to Ajay Chaudhary also, there are several judgments of this honorable court also. If your Lordships would like to have a look, I can just place two cases, and one is a reported judgment.
Just give me one case where something more about the reason has been said.
2023 4 GLT 113. Prasanto Datto versus State of Assam, coordinate bench, your Lordships.
There, I think elaborately.
Very elaborately held that the power of suspension should not be exercised in an arbitrary manner and without reasonable ground or in any vindictive misuse of power, which is exactly what is happening.
Give me
in
the
so far as-
paragraphs, please.
Paragraph 52, your Lordships. 52 is where this has been laid down. 5.2. I would have liked to take your Lordships to paragraph 31, 34, 39, 40, but I'm not troubling your Lordships.
No, I anyway have to read it. So you please.
Then in
read.
that case, I would like
You want to go home and you want to leave this exercise to me, huh?
No,
Mr. Kayal?
I'm willing to read the paragraph with your Lordships.
Yes, please read.
All right.
I have to, at the end of the day, author the judgment. So
Paragraph
either here or inside, I have to read. You see, here with you all, it is much better.
Much better,
Inside,
certainly.
all alone, it is very difficult.
Certainly, your Lordship, certainly. So in this judgment, paragraph 31, if I may take your Lordships, this is at
Yes.
page 126.
Paragraph
31. These were the
31.
31. Yes, these were the questions which had arisen for determination in that instant case. Whether a government servant, Lordships have got it? Paragraph 31.
Yes.
Whether a government servant who has been put under suspension would be entitled to a direction for reinstatement on the basis of the law laid down in Ajay Kumar Chaudhary, Supra, even though in the meantime, the memorandum of charge sheet have been served upon him. Number 2, what is the right of the government servant if the memorandum of charge sheet is served? Whether in the facts of the case, the petitioner would be entitled to reinstatement of his services. Right now, we might confine our debate to the first thing, whether considering the fact whether when he's put under suspension, would he be entitled to a direction for reinstatement on the basis of the law laid down in Ajay Kumar Chaudhary? Now, you also will kindly take up paragraph 34, which is where Ajay Kumar Chaudhary has been quoted, your Lordships. And this is the paragraph that I wanted to rely upon, paragraph 11 of Ajay Kumar Chaudhary. Suspension, especially preceding the formulation of charges, is essentially transitory or temporary in nature and must perforce be of short duration. If it is for an indeterminate period or if its renewal is not based on sound reasoning contemporaneously available on the record, this would render it punitive in nature. Departmental disciplinary proceedings invariably commence with delay, are plagued with procrastination prior and post the drawing up of the memorandum of charges, and eventually culminate after even longer delay. Protracted periods of suspension, repeated renewal thereof, have regrettably become the norm and not the exception that they ought to be. The suspended person suffering the ignominy of insinuations, the scorn of society, and the derision of his department has to endure this excruciation even before he is formally charged with some misdemeanor, indiscretion, or offense. I'll pause here for a moment, Your Lordships. This is the in paragraph 11 very categorically laid
object.
down. Yes, the reason why
Prolonged suspension.
the suspension. Then paragraph 39 for a moment, Your Lordships.
Paragraph
39.
39. Yes.
I'm going to read the whole paragraph, Your
Yes.
Lordships. Yeah. It is, however, also relevant to take note of that, as already mentioned in the rationale behind the observations in paragraph number 21 of the case of Ajay Kumar Chaudhary Supra, is with the perspective of moderation of the suspension orders in disciplinary departmental proceedings. It is therefore the opinion of this court that if the memorandum of charges or charge sheet is served upon the delinquent officer prior to an order of reinstatement, the right which accrued upon the delinquent officer for reinstatement for not serving the memorandum of charges or charge sheet within 3 months from the date of suspension, normal circumstances, and within 3 months from the intimation that the delinquent employee is released on bail or otherwise not in custody or imprisonment in the case of deemed suspension, would stand extinguished, subject to the compliance that the extension of the suspension is made by a reasoned order at the time of the service of the memorandum of charges or charge sheet. Now, this again is a factual thing which we are not really concerned with. Paragraph 40 for a moment, Your Lordships. This court further finds it relevant to observe that as the right to reinstatement springs from Article 21 of the Constitution and the law declared by the Supreme Court in the case of Ajay Kumar Chaudhary, a delayed adjudication of such right would run counter to the law declared by the Supreme Court in the case of Ajay Kumar Chaudhary. Thereafter, paragraph 42 is where again a discussion is held about the charges of the Ajay Kumar Chaudhary case, Your Lordships. Then may I take Your Lordships to paragraph 52. 52.
Yes.
From the above, it would therefore be seen that the power of suspension should not be exercised in an arbitrary manner and without any reasonable ground or as a vindictive misuse of power. Suspension should be made only in a case where there is a strong prima facie case against the delinquent employee and the allegations involving moral turpitude, grave misconduct or indiscipline or refusal to carry out the orders of the superior authority are there, or there is a strong prima facie case against him, if proved, would ordinarily result in the reduction in rank, removal or dismissal from service. The authority, while exercising the powers of suspension, should also take into account all the available material as to whether, in a given case, it is advisable to allow the delinquent employee to continue to perform his duties in the office, or his retention in office is likely to hamper or frustrate the inquiry. I'm going to pause here for a moment, Your Lordships. Factually speaking, the instant case, the case has been filed by 2 girl students. One of the girl students is an MA student. She has already completed her course, her MA degree in the meanwhile. That can be verified by the...
Let's not get into all that, Ms.
Factually speaking, I just
You
want
see, whatever be it, but the allegations are such that cannot be also ignored.
Correct.
So let us not get into that.
Certainly not.
Those students
Certainly
may
not.
have gone,
Yes.
but you see, at the end of the day, it's an institution.
Absolutely.
So
And therefore, I have completely and totally participated in the inquiry. I have asked
that is
them
okay. Your
very-
legal right, this court is looking into it.
Correct. Yes, Your
Because at the end of the day, suspension cannot be a punishment.
Punished.
That is the whole object, right?
Absolutely.
Yeah, and powers are there to the given to the appointing authorities, the disciplinary authorities. That is, in a given situation, you want to extend it, yes, you can.
Yes, you can.
But you must
definitely.
give reasons.
But they have not recorded any of these reasons in any of the
That is
extension orders. Yes.
on that I'm with you, Ms. Chaudhary.
Yes, Your Lordship. Paragraph 70. My last
The only thing is that here, Mr. Kayal has submitted that the rules doesn't require them to. Now this court have noticed that the rules also does not exclude the giving of natural reasons. Now, giving of reasons is a necessary concomitant of the principles of natural justice. This is for the employee, the suspended employee to
Lordships,
get an idea.
That
So-
particular
so-
provision of law came into force only in 2003. The law has thereafter...
Correct, it's progressed. It's progress and this is the
definitely.
apex court decision, so it has to be read with this.
Article 141 is absolutely a clear clarity, Your Lordships. I do not need to tell my learned friend
Unless,
about
of
the
course,
fact.
there was something there which says it cannot. That
Cannot, exactly.
in such a situation, suppose you see the government can come up with certain category of cases where the government can say, no, in these category of cases, reasons cannot be given. Then it's a different aspect.
Correct.
Then, of course, when a situation like this comes before this court is going to apply its mind. But
No
that,
such reason has
correct.
been given.
The,
And no
the,
such-
the rules does not say explicitly you don't have to give reasons.
Correct.
Yes, the rules are silent.
Silent.
Now,
That-
silent
that
doesn't
has-
mean explicitly excluded.
Correct. And that has now been developed by way
Correct,
of
by way of decisions of the apex.
saying that Article 21 also involves suspension, Your Lordships. Paragraph
On
7.
that, I'm with you. I'm just trying to understand the how this has been progressed.
Lot-
Only for that, you can just
Paragraph
please-
70 also, Your Lordships, of the same judgment.
Paragraph.
Paragraph 70, 70. The observations made herein above are relevant and pertinent aspects which ought to have been and is required to be taken into account at the time of reviewing as to whether the further suspension of a delinquent employee
That
is
is para
required.
70.
70, yes, Your Honor. I apologize. I'm reading from the second line. Merely because a disciplinary proceeding are pending, the authorities cannot keep the delinquent employee under suspension for an indefinite period, as the same would not only be affecting the rights of human dignity of the delinquent employee, but would also affect the administrative exigencies of the respondent state.
Okay.
That much, Your Lordships. And
You want-
the other decision, so let us say that one. I'm just placing a copy of that. It is not yet reported, Your Lordships. It's a recent judgment of this honorable court.
Justice Saikya.
Justice Saikya.
I think the other days I had an occasion to look into it.
Lordships. Similar, almost similar.
Pradeep
order.
Kumar Sharma. Yes. Yeah, the deprivation proceeding was concluded, correct? In
Yes,
th-
Your
in,
Honor.
in this case.
Yes.
Right.
Yes. And here was a case where the court held that there is no finding in the extension order that the petitioner may misuse his office for influencing any witness. If the inquiry itself is complete, then where is the question of me now?
Anyway, that we are
influencing
not on
witnesses?
that.
Yes.
Let us not unnecessarily explore
Correct.
it.
I do not,
Mr. Kal, yes, you're done?
I am done, Your Lordships.
Mr. Kal?
Placing one judgment of this honorable court. It is pronounced on 5/4/2025. I am relying on paragraph 12 only.
Ajay Chha.
Adhikari Sharma.
I think the
State of
Anake Mari, petition.
Adhikari Sharma.
In this case also, Ajay Chaudhary was relied on. Paragraph 12, Lordship.
Paragraph?
12.
Yes.
This court is conscious of the fact that the question of placing and or continuing an employee under suspension pending trial or conclusion of the departmental proceeding lies exclusively in the realm of executive, and unless the action is found to be wholly unreasonable and contrary to law, the writ court would ordinarily not interfere with the such decision, provided that it is established that the right of the employee has not been unduly prejudiced or due to prolonged suspension oblique pendency of the departmental proceeding. Lordship, further, I want to place here, Lordship, he was suspended in 2024 and now the proceeding is completed, Lordship. And I.
Okay. Noted.
Lordship.
Tomorrow morning statement. I mean, I'll dictate it in court because I don't think now there is time for dictating.
As per your.
So, do we refer that I heard MS RS Chaudhary. I always forget it's Sirotia. RS Chaudhary, Learned Counsel, appearing for the petitioner. Also heard Mr. S.C. Kayal, Learned Steering Counsel. So and so.
Lordship, I'm appearing for respondent number 5 UGC.
MS.
Dr. P. Agarwal.
Dr. P. Agarwal.
Yes.
Dr. P. Agarwal, Learned Counsel, appearing for respondent UGC.
Yes, Lordship.
UGC. Here, you are, I don't think,
Party, Lordship.
formal, but hearing is concluded. List tomorrow. This is coming under what column?
Admission.
Admission. So this should come as the first item for the admission column. List tomorrow as first item in the admission column to enable the court to make an endeavor to dictate the judgment in the open court.
Obliged, I'm deeply obliged.
I have kept it in the open court because there may be some clarification and
Certainly.
while I dictate the judgment, I generally prefer the counsels around so that, you know, the assistance can be also, I can take the advantage of the counsel's presence.
Deeply obliged.
এইখন আমাৰ নে এইখিনি একেলগে থব হা তোমাৰ সেই কেছ লগে থাকত গ'ল ইয়াত এইটো একেলগে ভিতৰত